My lord, given currency of a status quo order in the current petition, the circle officer has passed an order. My lord, selling in that, my lord, I have filed.
Circle officer passed an order saying what?
My lord, appointing the my lord, another person as Gao Pradhan of the village. So my lord, I have that petition is also fixed for my lord, admission day after tomorrow. So my lord, I may be taken up along with the petition.
With the consent of the petitioner's counsel, Malad, I beg to mention item number 23, Malad. I am for respondent of 1 to 6, Malad. I will file a affidavit today, Malad. Already ready, Malad. Let the matter may come after 1 week, Malad.
Lordship, on last occasion, last opportunity was granted to them.
Yes,
File it before.
You have objection?
No. Otherwise, the matter is otherwise settled by your lordship's judgment. Wherein you it's regarding NOC to join the organization. Wherein on earlier round of litigation, the same petitioner appeared before your lordship, and your lordship directed.
So what is to be done now? We are not hearing the matter.
I'm sorry, sir. Next week, your lordship, any day.
On the request of Mr. K.K. Parashar, Ranit CGC appearing for the respondents made with the consent of the other side, this matter stands adjourned for a week so as to enable him to file counter affidavit. List the matter again in the next week as a fixed item.
22nd, your lordship. Interim order may continue. Your lordship.
Interim order passed earlier to continue.
May I be your lordship? Lordship, I filed a writ petition, but can it be taken up for motion day after tomorrow, lordship? Oblige, lordship.
May I plead the lordship? I pray for listing of a writ petition for admission, lordship. Notice was issued on 18 and returnable by 4 weeks, but thereafter not listed, lordship.
Why it has not been listed?
Lordship.
Have you found out why it has not been listed?
Not,
Find out. There could be some defect somewhere.
notice was issued, but thereafter not listed, lordship.
Have you taken steps?
Yes, lordship.
Huh?
Yes,
Okay, then first week of April.
obliged.
May it please also. My lord, may I pray for listing of a motion matter on Wednesday?
May I please, Lordship. Lordship, I beg to mention for listing of a contempt petition, Lordship. Next week, Lordship, any date, Lordship. It's been pending since last year.
Lordship, I am paying for a motion matter, Lordship, on Wednesday.
Everybody wants, but what is the urgency?
Lordship, is on transfer matter, Lordship. That cancer patient is directed to be transferred in the Jammu.
May I please, Your Lordship, I beg to mention item 11.
Item?
11. For adjournment. Consent has been taken from the petitioner party.
You are for whom?
A standing counsel, G. Borderline, on behalf of standing counsel. He's out of town.
With the consent of the opposite party, the learned departmental council seeks adjournment in this matter with a prayer to list this case again after 2 weeks. Prayer allowed, let the matter be listed accordingly. Item 11.
Yes, sir.
I'm for the petitioner, Lordship.
Miss,
I'm for the
your name?
Kolita, Lordship. On behalf of A. Paramani.
Ms. B. Kolita is present on behalf of the petitioner.
May with lordship. I beg to mention for listing of 3 items, lordship. SSC matter for recruitment of constable, lordship. Matter is fixed after 4 weeks. I have entered in the registry. It is ready. But for large number of cases, I cannot list the matter without mention memo. So kindly allow me to list the matter.
When?
In the next week, lordship.
Next Wednesday.
Yes. Oblige.
May it please, Your Lordship. I beg to mention item number 42 on the daily list. I'm the counsel for the applicant, and the one-time settlement offer is still under consideration. I've taken the consent of the opposing counsel and
Item 42.
42, Your Lordship.
You want adjournment?
Yes, Your Lordship.
So this matter has been adjourned several times.
Your Lordship, the one-time settlement offer is still under consideration. It's being negotiated. The instructions for the counsel for the respondent is also the same.
You are for the bank.
For the applicant, Jalannagar Development Private Limited.
And who is for the other side?
Mr. Mukesh Sharma is not here.
You are Miss M. Das.
Yes, Your Lordship.
Miss M. Das, learned counsel appearing for the applicant in this case submits that the OTS proposal is still under consideration and therefore some more time be granted to bring the same under logical, to take the same, to conclude the same as per the requirements of the rules, full stop. The prayer is not opposed by the opposite side. In view of the above, this matter stands adjourned for 6 weeks.
My pleasure, Lordship. I beg to mention for listing WPC, Lordship. Next week, any day.
Why listing for what?
It is not listed, Lordship.
It has never been listed.
Till 21, Lordship, 2021.
Why it has not been listed?
No idea.
No, you get some idea, get idea and then come back. You ask the registrar, you must ask questions. Why is my matter not listed since 21? You ask. They are there to answer your questions. And then you come back, we'll allow it.
Lordship, I'd like to mention item number 10 with the concept of butter side. My senior is out of the station for treatment. Kindly adjourn this matter.
Adjourn for how long?
1 month.
For how long? On the
2
prayer of learned counsel for the petitioner, this matter stands adjourned for 4 weeks.
My
Yes.
pleasure, Lordship. Lordship, I pray for listing of 2 repetitions regarding non-payment of pension, Lordship. At any date, Friday or.
Next week, next Wednesday.
May I please your lordship, I need to mention WPC 8268 of 2022. Lordship, the petitioner is retiring this month and he has been suspended since more than a year. So could the matter be taken up at the earliest?
When you want it?
15th, Lordship.
No, you take it next Monday, 20th. 20th. We'll see what happens. 20th, yes, next Monday.
May I please, your lordship. My lord, I beg to mention for listing contempt matters, my lord, relating to pension, my lord. The petitioner is 78 years old lady, my lord. So, my lord, I may be allowed to list this matter, my lord.
You want to list it?
No, my lord.
You won't
Place
list
this-
it, huh?
No, my lord, I'm allowed to place this, my lord, mention.
Next week, next week. Put a date next week. Yes.
May I please, your Lordship?
Early of
I
late.
am praying for 3 content petitions, Lordship. Single matters, Lordship.
Mm.
May I pray it on
Next
Friday,
week,
Lordship?
next week.
And 2 repetitions. Lordship.
That's all, only 5. Next week. But if it exceeds the ceiling, it will go to May. So don't put too many matters in one day.
I have some mention, my lord. The listing the
How many?
One matter.
Only one.
One, my lord.
Oh. What is the matter? What do you want? When do you want?
My lord, this petition is for promotion, my lord, and it's pending for 2-3 years, my lord.
When do you want? At 2?
No, my lord.
When?
Next week or 10 days after 2 weeks.
10 days after 10 days.
Item 1.
Maybe,
Yes.
Your Lordship. In this case, I have challenged the award passed by the labor court, my lord. The fact is, my lord, the workman, the respondent number 4, was absent from the office. We issued short cause notice, which the departmental proceeding. He did not participate in the proceeding. But the reason he has shown in the medical certificate is from outside the mill, my lord. There's a hospital in the mill, my lord. And as for the rule, my lord, they must be checked by the doctors of the mill, my lord, which he did not do, my lord. He admits this one. But the learned trial court, my lord, labor court, my lord, kindly have a look at page number 170, my lord.
Number?
Page 171. The operative part. The first paragraph.
Yes.
The management ought to produce all documents of domestic inquiry, report to inquiry officer, second notice on a proposed penalty after holding such and such. Accordingly, my lord, you are reinstated. My lord, the question here, lord, please come to page number 141. Page number 141. Or before that, page number 140, the bottom, my lord. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10th line from bottom, my lord. It starts from before a workman proceeds on medical leave. Lordship has got it, my lord. From the bottom, it will come 10th line. From the bottom, upward, 10th line. Before cross-examination, this is.
Yes.
Before a workman proceeds on medical leave, he has to be examined by the doctor, the management company. I did not get medical checkup for the doctor of jute mill. Instead, I got medical check my health at Jaklabanda Civil Hospital. I have not submitted any medical document to show that I was examined by the doctor of the Jaklabanda Hospital. As per letter dated such and such, I was required to be present before the doctor of Assam Cooperative Jute Mill Limited did not appear before the doctor. It is not a fact that I misbehaved with the senior, my lord. This is what. Next time, kindly see, my lord, next page. It is not a fact that I submitted apology letter to SDO civil caliber in future. I will not repeat such thing. It is correct. He has done it, my lord. However, next line. I was not present before the inquiry officer for the purpose of domestic inquiry on 19/3/20. Or it is his admission, my lord. He was not present before the inquiry, in spite of repeated letters filed to him, my lord. On that basis, my lord, the order was passed, he was terminated from service. The matter was referred to the, my lord, labor court, and the labor court has kindly see the observation of the labor court, page 167. Kindly see the observation. First line, top. He was not present, this observation of the court, my lord. He was not present for domestic inquiry on 19/3/19. He has also denied the suggestion, he did not submit reply suggestions, my lord, that's what. Please come in the middle paragraph, my lord, bigger one. Let me read this one. He has testified inter alia that following several complaints against the applicant, workman for his immoral and illegal activities against the interest of the management, and also on the basis of complaint of senior assistant Sri Anup Kumar Fukon, workman misbehaved him in presence of jute supplier and threatened him to extinguish his life. Exhibit 2 show cause notice was issued against him. This is exhibited. He has also testified that workman created a disturbing situation in the male campus for which he had given an undertaking before SDO Civil. He was also found absent from duty without any intimation to the management authority. Under the above backdrop, the workman was issued show cause notice dated 13/3/20, and with failure to reply, the Departmental domestic inquiry was ordered and he was issued exhibit 3 notice to appear. There remained absent. Next, bottom item. This time also he did not appear. Therefore, the management, after conducting domestic inquiry, found him guilty of serious misconduct, my lord. Exactly. This labor court is found, my lord. He was absent of that day. And the medical certificate, people ought to have given it from the mean, my lord. Purposely has done it from outside, but did not submit that document, my lord. Since he did not appear in the domestic inquiry, did not participate, my lord. They had no option, my lord. They terminated, my lord.
Continuous absence.
I don't want it to be continuous, he was absent, my lord. So my submission today is, my lord, may examine the matter, my lord. And nearby this may be stayed because termination was done in long back, my lord. December 22. Around 3 months back.
No, but there is a provision for payment of his.
That we have passed the order, my lord.
Huh?
That will be done, my lord. There is no problem.
That we have already paid.
Oh, he has paid, my lord. That will be paid.
No, you are paying him for the current period also.
No, my lord, not for current period, but his PF or other retirement.
No, those you are bound to pay.
Lordship may observe that line, my lord. Lordship may observe that.
Which is that provision? Give the Industrial Dispute Act. It is 17B.
Yes.
17.
High Court, the employee shall be liable to pay such workman during the period of pendency of such proceeding in the High Court, Supreme Court, in full. Yes. Yes. High Court, the employee shall be liable to pay such workman during the period of pendency of such proceeding in the High Court, Supreme Court, and full wages drawn by him. The period in activity by the workman has been filed to that effect in such court. Yes.
You have to pay that.
My lord, lordship, that may be observation that may be made. We'll do that, my lord.
No, we'll say that you give an undertaking that
Yes.
it will be paid.
This is as per law, my lord, have to do. I can't say no.
All right. Yes. What do you have to say?
Looks like notice may issue.
Mr. Amnath, senior counsel, assisted by Mr. BP Boral, and counsel appearing for the petitioner, assailing the award dated 13/12/2022 passed by the learned labor court, Assam, Kamrup bracket M, in connection with case number 101/2022. Case U/S2A bracket numerical 2 number 01/2022, page 162,000. The instant writ petition has been filed, inter alia contending that the impugned award is vitiated by perversity. First of all, Mr. Nath, learned senior counsel for the petitioner, has further submitted that the award requires to be stayed. Full stop. However, the learned senior counsel has fairly submitted that the full wages to the workmen payable under section 17 capital B of the Industrial Dispute Act 1947 will be paid to him during the pendency of this writ petition. Full stop. I have perused the averments made in the writ petition as well as the impugned award. Issue notice of motion returnable in 8 weeks. Mr. J.K. Goswami, learned government advocate Assam, has appeared and accepted notice on response numbers 1, 2, and 3. As such, no formal notice is required to be sent to the said respondents. Extra copy of the read petition will be furnished to the learned government advocate Assam within a week from today, so as to enable him to obtain instruction. Petitioner to take steps for service of notice upon response number 4, the registered post with AD. Full step. Heard on the prayer of interim relief. Considering the facts and circumstances of the case, it is hereby provided that operation of the interim judgment and award dated 13/12/2022 shall remain stayed until further orders, subject to the condition that the workman stroke response number 4 is paid his wages under section 17B of the Act of 1947 without failure. Without any default, without any default.
Map region, petitioners are for them casual basis in the DRDA Kachar, office of the DRDA Kachar. And year 2005, 2012, 2015. After serving long periods, their wages have been stopped. For payment of their wages, the respondent number 3, that is 4, that is Chief Executive Officer, DRDA Kachar, has repeatedly requested the commissioner to release the fund so that they can get their wages. But that has not been done. So, my lord, this is my prayer to release their wages from since 2019 February. They are not being paid.
We'll have to issue notice in this case. Heard Mr. S. North Learned Counsel for the petitioner. There is the amendments made in the petition. First up, the petitioner is aggrieved by non-consideration of his case for regularization in silence and also for payment of arrear salary. First up, Miss N. Bora, Learned Standing Counsel, PNID Assam, prays for some time to obtain instruction. Issue notice of motion returnable in 8 weeks. Since Ms. Bora has appeared and accepted notice, all the respondents. Excuse me. For all the respondents, no formal notice is required to be sent in this case. Extra copy of the read petition be furnished to the learned department counsel, requisite in numbers so as to enable her to obtain instruction and file affidavit facilitating expeditious disposal of the read petition.
May please allow. My lord, this petition has been filed by the Assam Samoddu Fango. Their grievances, my lord, lordship knows under the Assam Tea Plantation Provident Fund, etc. Scheme Act of 1955, my lord. There is a fund, Provident Fund scheme, my lord. Now, where the matching contribution is made by the employer and the employees. Now, initially, my lord, when the act came into force, the expression employee is defined. Where it was said, my lord, an employee drawing a wage of 3,000 and below, in their case, there will be contribution from both employer and employee. Now, my lord, that slab of 3,500 increased from time to time with the hike in the wages. Now, in 2016, the last amendment was made, whereby, my lord, it was said that the ceiling was fixed at 15,000. Now, in spite of that, my lord, the matching contribution was being made by the employer and the employee, things were continuing. Now, all of a sudden, my lord, a notice under section 9BA has been issued by the employer, my lord, saying that we are going to stop the contribution from the employer side. We are against that. Now, my lord, in fact, my lord, I'll show from the pleadings, the conduct of the party has been to go ahead with this scheme. And in fact, my lord, despite there being a provision in the scheme, there is a provision in the scheme of the clause 17, whereby the ultimate adjudicating authority is the state government. In fact, there was a conciliation proceeding, my lord, where the matter was decided to be referred to the state government. So my humble submission is, my lord, until state government takes a call, the present practice should continue. That is one limb of the argument.
The other limb of the argument is, my lord, there is an English doctrine called doctrine of disuse, my lord. Now that has been applied by, my lord, our Supreme Court in 1995, where it says, my lord, not only a statute is not being given effect
So
to
that is doctrine of destitute.
destitute. Not only, my lord, the statute will not have been implemented, but there will be a, my lord, contrary practice. In other words, my lord, actions are being consciously being taken contrary to the statutory prescription. Then, my lord, in England and all there, they say the statute stands repealed. But Indian Supreme Court has not gone to that extent. But Indian Supreme Court has accepted the principle and started applying. So therefore, ever since 1955 till date, my lord, that statute has never been complied with. So where is the question of complying now? That judgment, can I show one paragraph?
Yes, yes.
My lord will kindly come to para 31.
Hmm.
In Cray's statute law, it has been stated at page 7 that destitute is a process by which an act of parliament may lose its force without express repeal. It does not, however, consist merely of obsolescence or disuse. There must also be a contrary practice which must be of some duration and general application. Then, my lord, these discussions follow. Eventually, if your lordship will kindly come to para 34. Though in India, the doctrine of destitute does not appear to have been used so far to hold that any statute should repeal because of this process, we find no justification in principle to apply this doctrine to our statutes as well. So ever since then, my lord, it is being followed. Now the question, now I'll just show one aspect of the matter. If your lordship will kindly come to page number 46, my lord. Decision to quote. Sorry, my lord. Page 34. My lord, this is the board meeting, board of trustees meeting, my lord, which was attended by, amongst others, by the concerned minister, and relevant portion is at page 38. Deduction of PF benefit of employees drawing salary above 15,000. I'll have your lordship's kind attention to the sentence starting with R. Kalita. R. Kalita stated that with enhancement of wage ceiling for PF membership from time to time to the present limit of 15,000, employees already enrolled but drawing wages exceeding 15,000 per month due to wage revision were allowed to continue PF deduction by previous resolution of the Board of Trustees. He expressed regret for the recent action of some employees for non-deduction of PF from the employees drawing salary of more than 15,000 per month. He suggested to refer the matter to the government of Assam and to continue the present status till amendment of the Act. The Principal Secretary stated that board will definitely provide all benefits as per the provisions laid down in the Act. He wanted to know whether actions can be taken where there is no provision in the Act. He stated that board has no objection to the provision of the Central Act. He suggested to refer the matter to the government of Assam for decision. After detailed discussion, member decided to refer matter to the government of Assam for decision. So, my lord, under clause 17 of the scheme, it is the government who has given the power to, my lord, take a call in such a situation. So, my lord, the Board of Trustees of the created under this scheme, they themselves has taken a resolution to refer the matter to this scheme. And thirdly, my lord, it will be an unfair labor practice because if somebody's wage is enhanced from time to time, and my lord, from the inception,
So what will happen now? Those who have more than 15,000
my
rupees
lord,
per
it can
month?
so happen after 2016, we have joined the services. In their case, it's okay. But those who are all, there is a vested right, my lord. And end of the day, my lord, it is a social security.
So that's right. So what happens because of the decision? Those who
Now
are,
they have not taken the decision, they have only issued a notice of intention under section 9A of the Industrial Disputes Act. So my humble submission is, my lord, till government decides, at least they should not, the present practice should continue. End of the day, my lord, it says social security scheme only. It's a provident fund contribution of the employer.
until a decision of the government is
Yes.
formally notified.
Yes.
status quo should be maintained.
maintained.
Even I don't know whether government has taken any step or not, my lord. This is a minutes of that, my lord, to the November 2022.
Yes.
So I don't know till that, my lord, government has taken any steps or not. Anyhow, my lord, not many issue notice. I am appearing only for one. Others are also left at the yes.
Heard Mr. Crenshaw and senior counsel listed by Mr. S. Chakravarti and counsel for the writ petitioner favors the amendments made in the writ petition. The petitioner union is aggrieved by the intention of the government to deny benefit of Provident fund to those employees whose wages exceed 15,000 per month. First up, according to Mr. Chaudhary, until such time, a decision is actually taken by the government to such effect and is notified. The respondents cannot deprive the members of the petitioner union from the benefits of Provident fund. First up, Mr. Chaudhary further submits that no such decision has yet been notified by the government. Hence, a prayer for issuance of an interim order has been made. First up, Mr. T.C. Chutia, learned additional senior government advocate Assam appearing for the respondent number 1, prays for some time to obtain instruction in the matter. First up, NOM 8 weeks since Mr. Chutia has appeared for the respondent number 1. No formal notice is required to be sent to the said respondents. The extra copy of the writ petition be furnished to Mr. Chutia. Petitioner to take steps for service of notice upon the remaining respondents by registered post with AD within a week from today. Hard on the prayer of interim relief. Considering the facts and circumstances of the case, it is hereby provided that it's hereby provided that status quo as regards the Provident Fund benefit presently available to the members of the petitioner union be maintained until further orders from the court.
Order stay vacated, item 4.
My lord, this application for vacation of the order passed by this honorable court. Now, what I'm thinking, my lord, without my lord going for a piecemeal argument. So if your lordship fix up for a hearing on 30th March, my lord, if it is convenient to your lordships.
Before 7th March is difficult.
I'm saying
Sorry, 7th April.
7th. By that time also it's okay.
All right.
Because if I have to argue, then I'll have to go to the entire merit of the case.
Mr. S. Dattal, senior counsel for the applicant, as well as Mr. B.D. Kaul and senior counsel appearing for the respondent, have both submitted in their usual fairness that although this IA has been filed, yet disposal of the IA would require this court to go into the merit of the matter. First up, therefore, instead of taking up the IA, the writ petition itself be fixed for final disposal at an early date. Taking note of such prayer made by the learned counsel for the parties and with their consent, this writ petition is directed to be listed again on 20th of April 2023
Yes.
as a fixed item for disposal along with the IA.
Much better.
Item 5.
May please, your lordship. And by order dated 17 to 23, my lord, your lordship allowed the petitioner to inflict, my lord, Central Forensic Science Laboratory as a party, my lord. I filed the IA, my lord.
Why you want to implement central for?
The petitioner was selected for the post of, my lord, SSB, my lord. Lordship. Because the verifications were pending before the forensic laboratory, lordship. From last 2 years, my lord. 2020, from 2021, it was pending there, lordship. So lordship was. And petitioner not yet appointed, my lord. Election list was published on 21/1/21, my lord. Till date, my lord, his verification regarding signature, my lord, is pending before the, my lord, CFSL, my lord.
All right, heard Mr. H.R. Rahman, Learned Counsel for the applicant. Also heard Mr. S.S. Roy, Learned CGC appearing for the respondents. This IA has been filed with a prayer to impeach the director, Central Forensic Science Laboratory, Lodi Road, New Delhi, 110003 as the respondent number 6 in the connected read petition. First up, I have perused the grounds stated in the IA justifying the prayer for impeachment. First up, Mr. Roy submits that he does not have any instruction to oppose the said prayer. In view of the above and considering the circumstances under which the IA has been filed, I deem it appropriate to allow the prayer made in the IA. First up, as such, it is hereby provided that the director, Central Forensic Science Laboratory be implemented as respondent number 6 in the connected read petition, registry to make necessary correction in the cost title of the read petition, IA stands disposal.
In the main notice has to go.
Notice will be issued in the read petition, in the correction in the cost title and list the matter for orders in the next week. Obviously.
Item 6.
May I please?
Yes,
I you my file for impeachment, my lord, that's one number 2 and 3, my lord.
you want to impeach whom?
My lord, impeach Vikram Koiri and Manish Thakur, my lord,
Hmm.
Commissioner of Inter-Rural Development and Commissioner of Finance, my lord.
What is the order which has not been, let us see the order.
In contempt petition, my lord,
Let us see the order.
Lord, she kindly see
Contempt is-
that's page 11, my lord. Eleven percent page 12, my lord. The petitioner is a master worker who was engaged as a peon cum chokidar in the Ramnagar Tarapur Panchayat as per to resolution number so and so. It initially had fixed pay rupees 400. Petitioner claims benefit of the direction of division method of this honorable court. It is judgment dated so and so. In Rita Bill number 45/2014, where it is provided that master worker, casual worker who have worked as more than 10 years, but against the post which may not be sanctioned, entitled to benefit of the minimum pay scale of an equivalent post. This stated Mr. M. Nath, and as counsel of PNRD, in this case, petitioner was initially sent to Finance Department, but the matter was remanded back to certain queries, and the answer to queries which was again sent to the Finance Department. This stated that claim of the petitioner is being considered within several many others. Similar claims, therefore, respondent would require minimum time in the process of its logical and Finance Department agrees that the claim of the petitioner would be given its financial considerations and brought its logical within a period of 6 months from the date of receipt of the certified copy.
So what do you have to say? Have you demanded compliance of the order?
My lord,
Where is the demand?
Lordship, I have only saw two pages, my lord, page 13 and 14, my lord.
Yes, all right, you take down her Jane and Rashkul and counsel for the applicant. This IA has been filed with a prayer to impeach the opposite parties numbers 1 and 2 as respondents in the connected contempt case. Mr. Lashkar submits that the OP numbers 1 and 2 are responsible for implementation of the court's order. First up, however, despite demanding compliance of the order by submitting the representations dated. What is the date of the representation?
Lordship, newly lordship, 15/12/2022, my lord.
Where does one find the date?
Lordship, I have indexed the postal stamp, postal receipt, my lord. 15/12/2022.
15/12/2012, sent to both the opposite parties. No action has been taken in the matter till today. First of, having heard the submission of learned counsel for the applicant, and in view of the statement made in the IA, The prayer in the application stands allowed. The OP numbers 1 and 2 are hereby implemented as respond numbers 4 and 5 in the connected contempt case. IS stands disposed of.
Obliged.
Important the office to make necessary endorsement in the cost item. IS stands disposed of.
I can start.
This is implement for the present contempt number is contempt number 5, my lord. Since that response number 3 already transferred, my lord.
All right, you are Mr.
JP Chauhan.
I have Mr. JP Chauhan, Learned Counsel for the, you have demanded compliance.
Yes, my lord, page 10.
This IA has been filed with a prayer to implicate the opposite party as respond number 5 in the connected contempt case. Mr. Chauhan submits that this opposite party is the new incumbent in the office of Deputy Commissioner Kachar and is therefore responsible for implementation of the court's order. However, despite demand made on that behalf by the petitioner, no action has been taken in this case. As such, the opposite party is liable to be implemented in the contempt case. I have perused the statements made in the IA. In view of the submission made by the applicant's counsel, the OP is hereby implemented as respond number 5 in the connected contempt case, registered to make necessary endorsement in the cost item. IA stands disposed of.
For admission, item 8.
May I please your lordship? Lordship, on the last occasion, they had given 3 grounds for termination of my claim. And 2 points we had already discussed on the last occasion, your lordship. The only one remaining was the amendment of the claim as per the policy condition number 7, your lordship. Lordship,
This is a parted matter.
yes, your lordship, this is a part of
Hard
it.
long time back.
Long time back.
What is the you're contesting?
Contesting in the sense, lordship, they have come against a judgment passed by the ombudsman in a insurance claim. So we are contesting in the sense that this is not the forum that they should be filing. They should have gone to the consumer court, first of all. And secondly, lordship had in fact asked the ombudsman office to provide the records, and they said there is a report that it is destroyed because of the time gap, lordship. So the ombudsman had refused. Had rejected their petition on 3 grounds. Like she said, 2 were discussed before lordship, and the third one was that there was a delay of 2 years, 7 months. So as per clause 7, condition 7 of the policy, the ombudsman said that it was a correct decision.
No, that is a different thing. Nobody has asked the opinion of the ombudsman. That we'll see, but the court had only called for the record.
After hearing lordship called the record, and then they said the report is that the record is not there. It's destroyed as per, because
What is the date or order of the ombudsman?
it was passed on 3/9/2013.
So without the record, is it possible to? We'll not dispose it today. Don't have patience. We can only fix it for a final hearing on some day. Without the records. What is to be done? You want a disposal today?
No, your lordship, I want relief. So if only record is to be called and somehow it comes up, then I'm for that, your lordship. I want relief.
But what to do? They are saying the record has been destroyed. Have you seen the office note?
Yes, your lordship.
What to do now? What is the way forward according to you?
Lordship, can I just say a few things, your lordship? Just one thing, your lordship. Even if the record is, let us enlighten is this way, your lordship. There were 2 orders passed by the ombudsman, your lordship. Now, why this is relevant for me, your lordship? When the first, we made a representation, then we didn't got any answer. Then we made move to the ombudsman, and the ombudsman passed the first order, which was in favor of us. Then we made another representation stating that ombudsman has given judgment in our favor and attached the copy of the order of the ombudsman. Then they sent us a representation. Then they sent us a letter stating that your claim has been repudiated. And then ombudsman passed second order. Now, your honor, as per the policy number 7, your honor. Oh, sorry, pardon your lordship. As per policy number 7, your lordship, I have already placed a policy in the record, your lordship.
Don't be so bothered about these things, your honor, lordship. These things don't matter much.
Okay.
Come to the point. What is the issue?
Now, lordship, as per that policy number 7, if only that is the correct policy, there should be there should not be any delay, and it should be, the claim should be made within 1 year, your lordship. Now, before repudiation, we had already placed our the grievances before ombudsman, insurance ombudsman tribunal, and then lordship, if the insurance ombudsman is a quasi judicial body, then how we have made delayed in placing our grievances before the honorable judicial court.
All right. Now the point is, we have to decide the matter without the records. Correct?
Yes, your lordship.
So then we'll fix a non-miscellaneous day and hear the entire matter. And finally
Your
pass an
lordship.
order. Heard Miss P. Das, Learned Counsel for the Late Petitioner, also heard Ms. R.D. Mojumdar, Learned Counsel appearing for the respondent insurance company. Payroll's office note dated 12/12/2022, which goes to show that the office of the insurance ombudsman has communicated to the registry that the records of the connected proceeding has been destroyed under the rules of the under the relevant rules. Full stop. If that be so, this court is left with no other option but to take up the writ petition for disposal on merit on the basis of materials available on record. Full stop. In view of the above and as agreed to by learned counsel for both the sides, registry will list this case for final hearing as a fixed item on 25th of April 2023. Parties to come-
25th of April. Lordship.
Yes,
Thank you.
parties to come prepared accordingly.
Deeply obliged, your lordship.
Item 9.
My lord, the matter relates to basically voluntary retirement, my lord. And of course, a disciplinary proceeding was also initiated. On last occasion, lordship directed my learned friend to obtain the instruction whether, my lord, they would also like to consider my prayer for voluntary retirement. Meanwhile, lordship also wanted to have a judgment on my lord doctrine of proportionality. I brought a 2009-15 SCC where, my lord, all the earlier case laws has been dealt with. Here is a case, my lord, where actually I was transferred from Silchar to Guwahati. Instead of putting me at Guwahati, I was sent to Borpeta.
Facts are, yes, sir.
I made a prayer, either you change or allow me to go on voluntary retirement. Then they initiated a disciplinary proceeding, and based on the disciplinary proceeding, my lord, I have been dismissed from service.
Yes, Mr. Bora. You have anything to say?
My lord, on last occasion, I have pointed out that, my lord, his voluntary retirement application or leave application, they were not in proper format. So that was not properly filed. So accordingly, it was not considered. And secondly, my lord, because since the year 2016, my lord, whenever he has been transferred out of Silchar, my lord, he has not joined his place of posting. And recently, my
No,
lord,
the question is, if we grant you the leave and ask him to file a application for voluntary retirement, would you do it?
my lord, that may be freshly done, my lord, because if your lordship
We'll
interferes,
keep the petition pending then.
my lord, because in that question, in that case, my lord, the dismissal from service, that has to be interfered with. So then after his reinstatement, he will be posted and then he will be again at liberty to file a fresh application, my lord. Because, my lord, otherwise his VRS application, my lord, that cannot be considered because the earlier application which has been filed, even in the disciplinary proceeding, my lord, he himself has deposed that he has not filed the application for VRS in proper format by enclosing all the documents. Because if a person seeks for voluntary retirement on medical ground, he has to enclose all the medical documents, my lord. So here, in his deposition before the disciplinary authority, he himself has stated. And in fact, my lord, after filing of the
No, see, the point is, he is already attained the age of superannuation.
no, my lord, no. No, my lord, because his present age is, my lord,
Actually, nowadays 65.
65, because
No, technically, my learned friend is correct, my lord. Lords will have to interfere with the order of dismissal.
Both things can't
No, my
happen.
lord, I think I'll retire only in my lord.
now it is, he is 61.
Another almost 2.5 years is left.
No, this is
No, 60 years into Bison.
right, sir. It is
I can
61.
say of 4 years is there, my lord. More than 3.5 years. No, on last occasion, lordship indicated that on the ground of disproportionate penalty, lordship will interfere, remand the matter. And simultaneously, I'll also file an application. My lord, to be honest, my lord, in the fundamental rules, no form has been prescribed, my lord. My lord, there are only two requirements that I have completed 50 years of service, or I have completed, sorry, I have attained the age of 50 years, or I have completed 25 years of service. Then I am eligible. And if I give a notice, then 3 months thereafter, it will automatically take effect. All the earlier case laws has been dealt with in this case, my lord.
And in this judgment, 2009-50, which para you want to rely on?
My lord, in fact, all the case laws has been referred to in paragraph 17, my lord. Not only 17, in all para. In fact, my lord, from para 16 onwards, earlier case laws has been dealt with, eventually at para 19. The doctrine of proportionality is thus well-recognized concept of judicial review in our jurisprudence. What is otherwise within the discretionary domain and sole power of the decision maker to quantify punishment once the charge of misconduct stands proved, such discretionary power is exposed to judicial intervention if it exercised in a manner which is out of proportion to the fault. Award of punishment which is grossly in excess to the allegations cannot claim immunity and remains open for interference under limited scope of judicial review. One of the tests to be applied while dealing with the question of quantum of punishment would be, would any reasonable employer have imposed such punishment in the like circumstances? Obviously, a reasonable employer is expected to take into consideration measure, magnitude, and degree of misconduct and all other relevant circumstances and exclude irrelevant matters before imposing punishment. But these are the, my lord, guiding principles. In fact, para 21, more or less same facts, minor. In a case like the present one, where the misconduct of delinquent was unauthorized absence from duty for 6 months, but upon being charged of the such misconduct, he fairly admitted his guilt and explained the reasons for his absence by stating that he did not have any intention or desire to disobey the order of the higher authority or violate any of the company rules and regulations, but reason was purely personal and beyond his control. And as a matter of fact, he sent in his resignation, which was not accepted. The order of removal cannot be held justified, since in our judgment, no reasonable employer would have imposed extreme punishment of removal in the like circumstances. The punishment is not only unduly harsh, but grossly in excess to the allegations. Exactly more same facts.
All right, then we'll close it.
Well,
Mr. Yanchori and Senior Counsel is stood by Mr. Arun Dekam and Constable. The petitioner also had Mr. B.P. Bora, Learned Standing Counsel, Health Department, Assam. Mr. A. Hassan, Learned Standing Counsel, A.G. Assam. Anybody else? Mr. B.P. Bora, you will put it for respond number
1, 2, and 3, my lord.
1, 2, and 3, and Mr. Hassan for respond number 4. Arguments completed, judgment reserved.
Divya.
Item 12.
Lordship, this is a compassionate appointment, Lordship. The petitioner's husband, while working as an assistant engineer under the Director of Municipal Administration, he died due to cancer, Lordship, on 24/12/2016. Thereafter, the petitioner has filed an application before the authority concerned on 20th January 2017 for her compassion in a grade 3 post. Subsequently, the DLC that was placed before the DLC, and DLC has forwarded the same to the SLC, Lordship. That was kindly turn to page 32, annexure 3, relevant portion 32, number 15, Lordship. In a grade 4, grade 3 post, Lordship. But thereafter, the authority did not take any action. And the petitioner also sought some information under RTI Act, Lordship. And in the information that was annexed to 3, Lordship, page 26, sought for under RTI Act. Page 27 is relevant portion, Lordship.
So what has happened? DLC has recommended.
Recommended, Lordship.
Then what has happened?
Thereafter, SLC had stated that there is no vacancy during that period. But actually, there is some vacancies in under the department, urban area, that municipal administration department, Director of Municipal Administration is under the Director of under the Department of Urban Development, Lordship. There is 2 wings. One, a municipal Director of Municipal Administration, and another is Lordship, Town and Country Planning. They have stated there is no vacancy. At that time, 28 vacancies were there. Out of 25% is 1.4. They have, in page 27, Lordship, they have mentioned that there is 28 number of grade 3 posts, direct recruit, promotional posts. That they have divided like that, but there is 5% is 1.4 in the Director of Municipal Administration, Lordship. But another wing under that Country and Planning, there is 7 posts at that time, Lordship. And they have mentioned in the affidavit on opposition, Lordship. 41 page 41.
Yes.
If it been filed by the government lordship, they mentioned there is a 7 post under the town and country planning lordship. And they have 5 posts they have already filled up and 3 posts were lying vacant. They can accommodate any as per memorandum of the government also.
Yes, Ms. Bora, what is your?
My lord, the case of the petitioner was considered by the DLC for a gate 3 post. The lordship may kindly have a look the affidavit filed by the department, my lord. The person who was appointed for the compassionate appointment, all are gate 4 posts. There is no gate 3 post available. There is the case of the petitioner was cannot be considered by the SLC.
Then she could have been considered for an alternative post.
Yes, gate 4 post as per clause 15.
Yes. Why it was not done?
It was not in our affidavit, but the there is an allegation that some other persons were appointed. But in our affidavit, it is stated that there is no person was appointed in the gate 3 post by.
All right, the office memorandum says if grade 3 post is not available,
My lord.
then alternative post she had to be offered.
Yes, my
Why
lord.
that was not done?
Lordship,
Just
in
a minute.
annexure 27, place 27, this specifically mentioned there are grade post 28 numbers.
Lordship, if I kindly have a look my affidavit, page 41 for a moment.
They can accommodate her in any other department lordship. As per memorandum
41.
dated 1st June.
41 for a moment, my lord.
Page 41.
My lord,
Yes.
my affidavit, my lord.
Hmm.
From the second paragraph, the meeting was presided by so and so. He delivered their position of Director of Ministry and Administration, Assam, and here the member secretary informed them there was no vacancy for consideration for appointment compensation ground as the posts have already been filled up in case of Director of Ministry and Administration, Assam. Then the vacancy question and the proposal submitted by the Directorate of Town and Country Planning, Assam came for deliberation. It was informed that since there are 8 compensation ground posts at 5% and since 5 have already been appointed, only 3 compassionate ground vacancies are left to be filled up as per point so and so. The committee noted names of the 7 candidates that can be considered for recommendation of 3 incumbent and compassionate ground, the date of applicant, etc., who died in harness, out of which 2 have preferred High Court case as different time. The detailed application were discussed upon by the committee in the light of the notification number so and so, and in the matter of the High Court judgment so and so, and there is a contempt case number so and so. Have been proceeded against non-compliance of the Honorable High Court order accordingly it is placed in the SLC. The next page, my lord, only 3 posts was available and the person had been posting as grade 4.
They have
Page
kept,
42.
they have kept vacant for their own person.
No, that's it. So her application was prior to them or not?
There is no mention about anything. Lordship.
There is Honorable High Court judgment direction regarding the compliance of this Honorable Court order. The person has been placed. And they
Where is
recommended
that order? Where is that order?
judgment, they had High Court judgment dated WBC 794/2014. Judgment dated 30/3/2016.
Where is it?
Is written in page 41, my lord.
No, where is the order?
They have not mentioned anything.
And another writ petition 279014 dated 26/2015. So only there is 3 vacant posts,
No, this is not going to serve.
my lord.
The court wants to know once the DLC has recommended her case for appointment against a grade 3 post.
Grade 3 posts.
First of all, you have to show that there was no grade 3 post available.
Madam.
Merely by saying will not do. Secondly, it is evident that grade 4 posts were available. So why she was not considered against the grade 4 post? That explanation you have to give.
Yes. But lordship, the judgment date is, if your lordship may kindly have the date of the judgment of this honorable court is 30/3/2016 and another is 26/2015. And the petitioner case was considered by the DLC in the 2017. So therefore, these cases are previous to the petitioner case. They have applied previously.
But
And there is only 3 posts is remaining as grade 4 post, but the petitioner case was considered for grade 3 post as there is no grade 3 post is available. And the person they have applied earlier before the petitioner, the department have to consider these persons. Since there is a honorable High Court direction also.
For that,
Just a minute, let
Yes,
me
sir.
understand. You take your seat. Yes. What is stated in the affidavit? Let us see.
Affidavit, Lordship, we have page 41 for a moment again, my lord.
Yes.
1, 2, 3, 4, 5, 6. Lordship, the seventh line in the, from 7 line to the second paragraph. The details of applicant were discussed upon by the committee in the light of the notification personnel be department office memorandum so and so, and the matter of the High Court judgment in case of WPC 794/2014, judgment dated 30/3/2016, and WPC number 279/2014 dated 26/2015. There is a contempt case number 90/2017 versus so and so being proceeded against non-compliance of the Honorable High Court order. Accordingly, it is placed in the SLC. The 3 cases has been placed for the SLC, my lord. There is only 3 vacant posts in grade 4.
So what is the date of application of these 3? You have to show us that, give us that particular.
Lordship, because this honorable judgment dated 30/2016.
Hmm.
So their date of application is before 2016. But petitioner has the consideration of the petitioner by the DLC in the year 2017. So we can assume, Lordship.
No, you give me the, where is the record?
Record, Lordship, I will produce the record. if Lordship.
Produce
My
the
lord.
record. Give us, and secondly, also show us that on that day, there was no grade 3 vacancy available
My
in
lord.
any other department. If these 2 things you can show, we'll close the matter.
My lord.
Otherwise, we'll allow the repetition.
Lordship.
Show us these things from the record clearly.
May I submit one thing, my lord? In the 2015 notification, clause 15, if there is no vacancy in the parent department, the case of the petitioner may be considered not for grade 3, for all grade 4 also for other department. They may consider,
Hmm.
but
So let's give the answer then. Once we issue a mandamus, then you can't go back on that.
I'll
Why
produce
it
the
was not
record.
done? I want to know.
My lord.
Your client is willing to join in a grade 4 post also?
Lordship, I have to take instruction
You
for
obtain
that.
instruction.
Because there are, for, as per that memorandum also, she can be accommodated in any other department.
That's right. But if no grade 3 is available, is she willing to join in a grade 4 post?
I will have to take instruction for
You
that.
take instruction. Next week we'll fix it. So and so, next, fix the matter again on next Wednesday, so as to enable the learned department council to produce the relevant records.
My
Of
lord.
like- Yes, lovely.
There's enough, think to my lord.
Yes, just 5 minutes.
Published. Annexure 1, page 17.
Is it a covered matter?
Lordship, no, it is not a covered matter, Lordship. He was.
It'll take some time. How much time will it take?
Lordship, that maximum 15 minutes, Lordship.
After other matters are over.
May I please, your lordship?
Yes.
Due to discrepancy in respect of extracurricular marks, lordship petitioner is not eligible for the post of AV constable, lordship.
Not eligible.
Yes, lordship.
Then what can be done?
Actually, he has submitted a 2 computer application before the competent authority. But other affidavit in opposition is shown that 1 year computer application has been submitted, getting a marks, 4 marks, lordship. Petitioner has got 57.60 lordship marks.
So is there any interim order in this case?
No, lordship.
All posts have been filled up.
Yes, lordship.
Field up ballot is from Sipsagar district ballot.
Hmm.
The petitioner mark cut-off ballot for general candidate, it is given in our affidavit. Let's say kindly see our affidavit. File record number 3, election board. Election board. Page 3. Petitioner Sri Tarif Ahmed belongs to general category and he had scored marks as shown below. PET, physically efficiency test, 8.5 marks, 1 mark, so and so, 40 marks.
And extracurricular activities, special skill 0 marks. And written test 17.5 marks, total 57.50 marks. Whereas the last selected candidate against unreserved post, Moinuddin Ahmed has secured 60.50 marks. So that's why petitioner is below the cut-off marks. That's why his name is not placed in the final select list. That is his case, my lord. He says, my name is not placed in the final select list.
So according to him, he should get some mark in extracurricular activity.
Yes, Lord.
How much?
Extracurricular lordship, he is entitled to 4 marks lordship as per advertisement.
How, show me?
Lordship affidavit, lordship respondent 05 lordship.
No, from your petition, you show me what affidavit.
Lordship,
What is it?
I have submitted a 2 computer application lordship. 1 year and one is 1 year lordship computer application and another is 4 month lordship. But who has been submitted 1 year computer application, he will get 4 marks lordship.
Where is it? Which page?
Already I have a reply affidavit in lordship. Computer application is annexed there with lordship.
Hmm.
1 year lordship.
Which page?
Lordship affidavit in reply lordship.
That's correct. Page number?
And extra lordship. Page number 7 lordship.
Hmm. So this is Universal Institute of Information and Technology.
Yes, lordship.
Hmm. So where does it say it will get 1 mark? Advertisement, which part, which para of advertisement?
Advertisement lordship, kindly see affidavit in opposition lordship.
Hmm. Yes.
Lordship page 9 lordship. Affidavit in opposition lordship.
Hmm.
Extra curriculum activities and special skill. 15 marks lordship.
Yes.
Number 3 lordship, diploma, technical qualification from ITI, Polytechnic or other recognized institute or in computer application from a recognized accredited institute marks 5 lordship.
And how much you got? They gave you 0.
0 lordship.
Hmm. What do you have to say, Mr.
This whatever he drew, from the records, I will have to say, my lord. Now record is not with me, and now his certificate is lordship. Here is one of definition is there regarding certificate, diploma, technical.
No, Mr. Chutia, you see, these are nothing kind of an argument. You tell us why this certificate, which is in his affidavit in reply, page 7, whether he was given any marks for this, if so, how much, if not, why not?
Yes, my lord.
Why?
My lord, whether this certificate is acceptable or not, my lord.
This was submitted along, you have submitted this, Mr. Gogoi,
Yes,
did your client submit it?
Yes, lordship.
You have stated that, where is the statement? That it was submitted along with the application?
Lordship, I have submitted stated on the affidavit lordship.
No,
Where is
no,
it? Where is it? Where is the statement?
Paragraph 7 lordship.
But you did not say so in your writ petition.
Yes, lordship. That was the time client has not furnished me. That is why lordship, I have not annexed the hearing, lordship.
all extracurricular activities certificate have to, my lord, produce at the time of, my lord, selection and PET or TSP, my lord, not before that.
Hmm.
When they will appear for physical assistant, they will have to produce it.
So you tell the simple answer is whether this document was given and what was the mark given to the petitioner.
Always says, whether document was submitted or not, my lord, I would have to ascertain.
Do it at 2 o'clock.
Not 2 o'clock,
Then?
2 o'clock, another matter he speaks for me.
No, another, you will have many other matters.
My lord, today,
Another matter in a bigger court.
today is Monday.
A more important matter.
Important.
Lordship, they have this.
It is also important, my lord. I am not saying.
Can't say.
2 p.m., my lord, I will have to call for
Day after tomorrow.
day after tomorrow.
Mr. P.K. Govil and counsel for the petitioner is present on the request of Mr. P.C. Chutia, Leonard, additional senior government advocate Assam. Let this matter be posted again day after tomorrow, that is so and so as a fixed item. So as to enable him to obtain instruction. Just obtain that instruction in
Yes.
writing.
On the basis of the
Yes.
certificate. Right.
Item 15.
May it please your lordship, here in this matter, I was supposed to file an additional affidavit, lordship. The same could not be filed, lordship, because there were some subsequent development, lordship. Lordship, there was a DPC which was conducted on 10th of March, lordship. And in the same DPC, lordship, the petitioner was considered for promotion, lordship. So I will need 2 weeks time to file, to bring everything on record, lordship. Lordship, DPC was held and he was considered for promotion, lordship.
Lordship, I am pleased to peruse the orders dated 16/12/22, 19/1/23, and then 20th of February 23. Since last more than 3 months, Lordship, they are taking time.
No, but he says on 10th of March, GPC was held.
Held, lordship.
10th of March.
Yes, nothing
was-
has been communicated to me.
That's what he wants to bring on record.
My, okay.
All right, heard Mr. S.P. Roy, Leonard, counsel for the petitioner also heard Mr. D. Upamanu, Leonard. The Standing Council Health Department Assam who submits that although there is already a direction from this court upon the respondents to file affidavit, yet there has been some subsequent developments as a result of which the affidavit has not been filed till today. Full stop. According to Mr. Upamanu, the DPC was held on 10th of March 2023, wherein the candidature of the petitioner was also considered, and therefore he seeks 2 weeks' time to bring the said facts on record along with the outcome of the DPC. Full stop. DPC proceeding. Full stop. Mr. S. Dutta, Leonard Senior Counsel, is
Respondent
present
number
on
3.
behalf of the respondent number 3. On the request of Mr. Upamanu, this matter stands adjourned for 3 weeks. Affidavit on behalf of the department will be positively filed within 2 weeks by serving advance copy upon the petitioner's counsel.
Highly obliged.
Obliged. To find out.
Item 16.
May I please your lordship? Lordship, the matter pertains to selection of respondent number 5, my lord. My lord, here in this case, my lord, applications were invited, my lord, for filling up the post of typist under Foreigners Tribunal 1, Morrigaon, my lord. I take your lordship to page number 24, my lord. In which, my lord, petitioner was in the merit list as serial number 1, and the respondent number 5 was as serial number 2. Thereafter, at page 26, my lord, the respondent number 4 have issued me a letter stating me as I was in the merit list as serial number 1, I was directed to ask for 2 certificates with regard to my character from 2 respectable persons and 1 medical fitness certificate from 1 medical. As I have submitted all those documents, my lord, and thereafter the interim order was passed in which, my lord, the respondent number 5 was selected in place of me, my lord. So this is my case, my lord.
But there is an order. I appear for the private respondent, my lord. There was an order passed by this honorable court to produce the records.
Who is for
Because
the,
I am the beneficiary, but they have to justify.
who is the departmental counsel here? Sorry,
FT, my lord, FT, foreigners
FT.
typist. There was a advertisement for the post of typist,
Typist, my lord.
typist. So accordingly, my learned friends and I appeared for the interview. On the basis of the interview, my lord, undoubtedly 49.5%, I was 49.
Hmm.
So I have been selected. And
so
I was
how
appointed.
a higher mark?
Yeah, that's right, my lord. The court want to see the record
Hmm.
because 2 certificates has to be produced at the time of the interview. So I think that's why the court wanted to see the records. Why? This 49.5 and 49.
What is this? Records are here, but the council
There
is
is
not
an
there.
order passed by this court, no? Order.
Sir, records assembly. Sir, records assembly.
Sir?
Who is the council? FT council.
Who was there, I think? Big one.
Who's the SCFT?
I met him also. I said you remain because they met him. I don't know.
Who?
Mr. Pegu.
Let's fetch him. Just be there for 10-15
Yes.
minutes. Let it put it in G Pegu SCFT, I will like. And once he comes, give him this record and this to check. We'll call out after some time.
Item 17.
No, in this case, today itself, I am going to file a within opposition, my lord. And or short copy, my lord. And the thing is that, my lord, earlier we filed an affidavit wrongly, my lord, in same name of the petitioner is Durga Kishan store, my lord, that was also same, my lord. So it was filed wrongly in this case also. That another matter, 16 item, 16 of 2020, my lord. It is 2014, 14 of 2020. So today, the right affidavit is filed, going to file today itself, my lord. So earlier, affidavit may be allowed to withdraw, my lord.
How can it be done? How do you withdraw an affidavit?
Today I am going to file
You have to
this.
file an IA then. Affidavit cannot be withdrawn
Yes.
like this.
Then this, whether I'll file today itself or what? Board allowed. Okay, okay. my lord.
What do you have to say?
We received today,
Your name, please?
Peace.
His Peace and Learned Counsel for the petitioner submits that a copy of the counter affidavit proposed to be filed by the respondents has been served upon her. Mr. S.K. Mehdi, Learned Counsel for the respondent submits that although the counter affidavit is ready for being filed, yet there is a mistake in this case, inasmuch as earlier an incorrect affidavit was filed on behalf of the respondent, being confused by the name of the parties, which resembles name of the parties in this case, although being confused by the identical names of the parties in the case, although the said affidavit pertains to another matter. First of Mr. Mehdi therefore seeks leave of this court to file fresh counter affidavit along with an application to withdraw the earlier affidavit filed on
My lord, this was filed on.
dash from the record of this case. Prayer allowed, let this matter be listed again immediately after the IA is filed by the respondents. You give the date of the earlier
Yes,
affidavit.
my lord. I'll state, my lord.
Item 16.
I told you, after case I argue. No,
My
he
lord,
has to justify.
You have seen the records.
Yes, my lord, I have the records, madam. I want to file a short affidavit, my lord. The my lord, member is out of station due to her medical ground. Madam. Can it be after 17, any day, madam? I will file by 20th, madam.
20th of March.
Yes,
All right, heard Ms. S.G. Barua, Learned Counsel for the petitioner, also heard Mr. G. Pegu, Learned SCFT, who submits that he has received the records and seeks time till 20th of March to file a short affidavit. Mr. D. Das, Learned Senior Counsel, assisted by Mr. S. Sharma, R. Sharma is present on behalf of the respondent number
5.
Respondent number 5. On the request of Mr. Pegu, Learned Departmental Counsel, this matter is directed to be posted again on 24th of March 2023 as a fixed item. So as to enable him to file affidavit. Records will be with whom?
Record, my lord, the one.
The records be retained with the case. The records received be retained with the case.
Item 18.
Lordship, in pursuance of the advertised dated 2/9/20, petitioner had applied for the post of Gambra, Lordship. Accordingly, he had appeared in the interview and he was selected for the post of Gambra, Lordship. Yes, due to some complaint filed against the petitioner, respondent authority have not been appointed the petitioner only for purpose of his residential address, Lordship.
File a appeal.
Complaint against the petitioner only for permanent residence of Lordship.
Divisional Commissioner.
Yes, sir.
Huh?
In the file and the appeal.
150 to see.
Why don't you approach the divisional commissioner ventilating your grievances?
Lordship,
Approach the divisional commissioner of the that is divisional commissioner Aparasam.
Lordship.
Approach him, we'll ask him to look into a grievance and pass an order within 4 weeks. Heard Mr. P.K. Gogoi, learned counsel to the writ petitioner. Also heard Mr. J.K. Goswami, learned government advocate Assam appearing on behalf of the response numbers.
2 and 3, Lordship.
So then I got a Mr. J. Henry, learned SC revenue for 1 and Mr. J. Goswami for 2 and 3. First up. Pursuant to the advertisement notice dated 02/09/2020, issued by the Deputy Commissioner Tinsukia, that is the respondent number 2. The petitioner had submitted his application for appointment to the post of Gaonbura under the Tinsukia Revenue Circle at Tinsukia. First up, on conclusion of the selection process, the petitioner's name figured in the final select list. First up. However, although the petitioner was selected for appointment in the post of Gaonbura, no order of appointment has been issued in his favor to today. First up, Mr. Gogoi submits that the authorities have withheld the appointment of the petitioner allegedly on account of a complaint lodged by a third party questioning his place of residence.
Lordship.
To contend that questioning his place of residence by urging that the petitioner was not eligible under the advertisement notice dated 02/09/2020. According to Mr. Gogoi, those are completely false allegations in as much as the petitioner has sufficient documentary proof to establish his place of residence, but no authority has looked into his grievance till today. Full stop. The learned Departmental Council submits that under Rule 162(c) of the executive instruction issued under the Assam Land and Revenue Regulation, the grievance of the petitioner can be examined by the Upper Assam Divisional Commissioner in an appropriate appeal if preferred by him, and therefore the writ petition can be disposed of with such a direction. First up, the petitioner's counsel has also agreed to the recourse suggested by the learned Departmental Council. In view of the above, this writ petition stands disposed of by granting a 10 days time to the petitioner to prefer an appeal before the Upper Assam.
Lordship, 20 days, Lordship.
20 days.
20 days, Lordship.
3 weeks time to the petitioner to prefer an appeal before the Upper Assam Divisional Commissioner, ventilating his grievances in the matter. If petitioner submits such an appeal along with a copy of the order passed by this court, his grievances be looked into and the appeal be disposed of with a reasoned order, preferably within 4 weeks thereafter. Full stop. With the above observation, writ petition stands closed.
Highly agree.
Item 19.
May I begin? The prayer before Lordship, my lord, taking a direction of the court for giving promotion to the post of senior assistant from 1/10/2005, my lord. Earlier I was given promotion effect from 1/10/2015, my lord. What has happened, my lord? There was just in 2015, there was a direction of the honorable court, because I was initially appointed as a copyist, my lord, in year 1980s, my lord, but I was never promoted. So I prepared a petition, my lord, and this honorable court directed me to immediately give a promotion to the post of LDA, my lord. But
So
they have-
now you have got the promotion.
No, you also can listen. But they never appointed me as LDA. Just before my retirement, they have appointed me as a senior assistant without being LDA.
Senior assistant is higher than it.
Yes, my lord. Because fact that I was holding the post of senior assistant since 2005, my lord. That is admitted fact. I was holding charge. My lord. So I approached this honorable court, my lord, and ultimately, my lord, the secretary to the government of Assam, my lord, they have wrote to the deputy commissioner, my lord, to give me appointment till 1/10/2005. They're saying there is no vacancy. Since there was no vacancy, that's why no appointment came. Fact, when I was holding that post,
Since 2005, my lord,
So you retired as senior assistant.
senior assistant.
When did you retire?
I retired on 2018, my lord.
No, I want the date.
Wait, I'm giving the date. I retired on 34/2018, my lord.
30/04/2018
Yes, my lord.
as senior assistant.
As a senior assistant. my lord.
And where is your order of retired superannuation? Let us see.
That is not there, because I was already given promotion, my lord, that your lordship can that order, my lord. That is page 32, my lord, and Annexure 7, my lord. That is on 13/7/2016, my lord. Is promoted vacant post of senior assistant in Kaya Revenue Service. But I was never appointed as a LDM from
Okay, so is this order under challenge?
this one.
This one?
This is not on the challenge, my lord. Now what happened, my lord? Subsequently, my lord, they have modified that order, my lord. Your lordship will kindly come page 37.
Mhm.
There was direction of the order in 2018, my lord. And in terms of that order, my lord, they promoted me, my lord. Your lordship will kindly come page 37, Annexure 9. Last line, my lord. In compliance with the order dated so and so. He was promoted a post of with effect from 1/10/2015, my lord.
So
There is-
now you want with effect from
1/10/2005. Because the fact your lordship can, there is a communication issued from the government, your lordship kindly come to page 52, my lord. Page 52, your lordship will find Annexure 12, my lord.
No, just a minute. No, Mr. Kotak is, see, the problem is whatever the government has given,
Yes, ma'am.
that is 1/10/2015.
15.
You want another 10 years.
10 years.
So
ma'am.
this will, if you succeed, it will be only for notional purpose.
Yes, I understand. ma'am.
But unless you challenge this order, how can the court say that give it from 2005, not 15? The court has to say that this order is wrong.
No,
It
the
has to be
fixation was
certified.
wrong. We earlier we also paid for 1/10/2005, my lord.
That is correct, but is this order not required to be challenged?
No, because government also has requested the deputy commissioner to fix the date, my lord.
You know it, without challenging this order, the court cannot pass the court has to set aside this order. And
No, which order, your lordship? This
page 37,
page 37, my lord.
yes,
No, what prayer was rejected. Again, we file application.
that's a different thing. But
Yeah,
now the department, see, deputy which has Borwal and government advocate Assam appearing for respondent first.
Respondent number 5.
Hearing for respondent number 5 submits that she has received instruction and therefore 2 weeks time be granted as last chance to file affidavit. Mr. S. Dr. Learned Counsel
For respondent number 3.
is present on the respondent number 3 and Mr. S. Alam for respondent number 8. S. Alam Learned Counsel for respondent number 8, who also pray for some time to file affidavit. The remaining counsel for the respondents are absent.
May I please, Lordship? I am appearing for 1, 2, 4, 5, and 6.
Okay, age group of 1 to 4, 5, and 6.
7 also.
6 and 7. All right. The remaining counsel Nalaway. On the request of Ms. Borwa, this matter is directed to poster again after 4 weeks. In the meantime, affidavit be positively filed by serving advance copy upon the petitioner's.
Interim.
Huh?
Interim order.
Interim order passed on the.
On last occasion, it was not continued. Yes. On last occasion, it was not-
I paid my lord.
What is the interim order?
Status quo.
Status quo regarding what?
Regarding the post of Gaura, lot number 5. That is I am holding my lord. Just wanted to tell.
Oh, interim order has been vacated now.
There is
My lord.
coordination, Lordship.
Huh?
All the
There
case
is no
was.
coordination.
Has
Although
anybody
last
been-
occasion It was paid, Lordship, but it was not continued.
But is there any appointment made in the meantime?
Yes, I've been appointed. I'm serving my lord. I'm serving. That is the status quo with on the first
What
order.
is the order? What is the interim order?
Yes, my lord. First order is my lord, page 2711 to 2710 22, my lord. Status quo, my lord. Status quo has to maintain till the next day. Thereafter it was continued simultaneously. Thereafter, my lord, on my lord,
Post appointment to the post of Gavura, what does the status quo order mean?
my lord, appointment was made to the private person, my lord. That was challenged by me, my lord. I challenged it before the commissioner, my lord. Commissioner allowed me and directed to appoint me. Thereafter, that was accordingly appointed me, and I have joined, and I am also serving. Thereafter, they filed repetition before this honorable court directed to file review, my lord. Then they filed review, my lord. In review, my lord, only one, my lord, on the ground, only on ground, my lord, that.
What is the status quo in this? I have been appointed, so status quo. Status quo means you will not be appointed then.
Prior to passing of the order of appointment.
You file an application. Yes. You are not being able to explain to the court what is the meaning of status quo.
Then,
Huh?
can take it after some time, my lord.
Next matter. Next matter.
Item 26.
Yes, what is this?
By this referral, I have challenged the particular office memorandum point number 1 of the regarding compassionate appointment, and this coordinate bench already set aside that point number 1, covered case,
So it is covered case. Mr. K.R. Patgiri, learned counsel for the petitioner, submits that the issue involved in this writ petition is pertaining to the claim of the petitioner for appointment on compassionate ground, which prayer was rejected by the SLC on the ground that the petitioner's father did not have 3 years of service left at the time of his death. First of such a view was expressed in view of clause 1 of OM dated 1/6/2015. However, by the judgment and order dated
31.
there is an appeal pending against the judgment.
No, no, my lord.
Huh?
No appeal has been filed, my lord.
The other day, somebody said there is an appeal preferred. You are not aware.
Order dated 31/2023. Yes, my lord.
Covered under the judgment and order dated 30/1/2023 passed by the learned single judge in WPC number 1646/2021 and the batch of connected writ petitions, whereby clause 1 of IM dated 1/6/2015 has been struck down and the matters rejected by relying on such and the applications rejected earlier by relying upon such OM has been remanded for reconsideration. First of Mr. Patgiri submits that a similar order be passed in the present case as well. Full stop. Mr. J.K. Parajuli, learned government advocate, Assam, appearing for the respondent, has agreed to the proposition made by the learned counsel for the petitioner. In view of the above, and on perusal of the judgment and order dated 31/2022, I find force in the submission of Mr. Patgiri that his case is covered by the aforesaid judgment of this court. Full stop. Accordingly, the resolution of the SLC recorded in the minutes dated, what is the date of?
3/9/22, case 30, my lord.
3/9/2022.
2022, my lord.
2022, qua the writ petitioner is hereby set aside. The matter is remanded back to the SLC for a fresh consideration of his case. It's a male or female?
My lord, male, my lord.
Fresh consideration of his case. In the light of the decision rendered in the case of, decision of the learned single judge, as referred to here in above. The petition stands closed.
May I please hear that?
And my instruction is awaited. Otherwise, my lordship, can you see page 25 for a moment, madam?
No, you want to obtain instruction?
Immediately I filed my affidavit. Otherwise, my lord, the petitioner was not found eligible despite there being vacancies. My lord.
You are appearing for?
Health department, my lord. That's for 1, 2, and 3.
I am appearing for private respondent number 4, 6, and 7.
So we'll grant him how much time you want?
Let it be after 3 weeks, my lord.
Let him obtain instruction. Heard Mr.
S.A.
S. A. Hussain, learned counsel for the petitioner, Mr. B. Gogoi, learned FC Health and Family Welfare Department, appearing for the respond numbers 1 and 2.
1 and
Submits
2.
submits that the instructions are still awaited, and therefore he be granted 3 weeks time to obtain instruction. Mr. J. Patwari, learned counsel for the respond number
4, 6, and 7.
4, 6, and 7, and Mr. J. I. Gorvia,
5 and 8.
learned counsel for respond numbers 5 and 8, also pray for some time.
Affidavit is submitted by our.
Are present. However, in view of the prayer made by the learned department council, this matter stands adjourned for 4 weeks.
Item 28.
Well, I was to file an affidavit, I could not file it. Well, I need some time. Apart from that, my lord, petitioner 6 for relief under Ajay Chaudhary. Ajay Chaudhary has been interpreted, my lord, in a different way by the bench of this court, my lord. That time period of when the time period of 3 months starts, my lord. In this case, petitioner was in jail. So the honorable court has laid down that the delinquent has to come out, has to inform the authority, and upon them, then only, my lord, this 3 months run.
My lord, not that, my lord. Petitioner was placed under suspension under 6(2), my lord. There is a
Have you seen the recent judgment? of the-
Yes, I brought, my lord. 2 judgment of the division bench, I brought it, my lord. One is the reclusive,
No, no.
one is the GLP of
This is, my lord.
2004, my lord. In the both case, it's
No, this is 17 to 23.
Have you seen this judgment?
This is, my lord, Rafid Ali. It says, my lord, the 3 months, 3 months count from the date he comes out from jail, informs the authorities that I'm out.
Examine it.
my lord, we'll see, my lord, one thing, my lord. Let them show a single document, my lord, within the period of 90 days from my suspension, whether the review was there or not, my lord. Lordship, kindly have a look the last order, my lord.
There is another judgment of 2023 February. Are you aware?
Not the 2000.
Then find out. There is a
Yes,
division
I'll
bench
just-
judgment.
I'll give it back.
May I come up
After
on-
that also, some judgment which came 2 weeks back.
And that apart, my lord, there's a provision, pen, this rules for a moment, my lord. This rules, my lord, there's a category C, subcategory, sub rule, my lord. It says.
This issue has been largely addressed by another subsequent judgment. I am the author of the judgment. Please have a look and see. with-
My lord,
That's 2 judgment, my lord. I'll just
Request
take it
of
up.
learned counsel for both the sides, this matter stands adjourned for 2 weeks.
My lord, short date, my lord, last, any day by Monday, my lord.
Yes, yes.
Monday.
All right.
Item 29.
This has been filed due to pending DP for the last 5 years now. West for direction, my lord, for early disposal of DP. They are supposed to file an affidavit.
Yes, Mr. Chutia.
My lord, my instruction is, my lord, when he is, my lord, case of promotional revenue is come, then my lord, they will keep it on a seal cover, my lord. Departmental proceedings is going on, my lord. They want for the witnesses.
That is his grievance. It's going on since very long
But
time.
is, my lord, pending DP, my lord, he may not be promoted. That is his grievance. Pending departmental
We'll
proceedings.
quash the DP on the ground of delay. What do you have to say on that?
My lord,
We'll quash the departmental proceeding today.
departmental proceeding, my lord, departmental proceeding is going on. There is no informative, my lord, irregularity in doing the departmental proceeding.
When was it initiated? DP?
My lord,
DP was initiated when?
2018. 2018.
Then we have 5 years down the line, what infirmity? That is the infirmity. Yeah, you want everything in super fast speed, everything is happening everywhere.
Lordship, otherwise, can dispose of the matter directly, then direct them to expedite the DP. That will I have
Now,
nothing.
what
to
is
say.
the state of the DP now? What is the stage?
I don't know, this instruction is January 2020.
At who you come, Mr. Chakravarti, you obtain instruction, what is the
Yes, sir.
stage? We'll dispose it of, yes. We'll dispose of the matter.
Lordship, I've received instructions, very Lordship, to pay for 2 weeks time for filing affidavit, Lordship. 2 weeks time, Lordship.
My lord, in fact, my lord, the issue has already been taken care of by this court, my lord, in several judgments. And I'm relying on your lordship's last order, where my lord was the author of the judgment pertaining to the selection of constables in the paramilitary forces. My
These
lord,
are covered
it's
matters.
a covered matter, my lord.
Lordship, let me take the instruction and file an affidavit. They want to file an affidavit, Lordship, short date, Lordship.
No, that's all right, but is it not a covered matter? So many orders have been passed.
Several
They
orders.
approved very lately, Lordship.
Huh?
They were the fence seater, Lordship. Others approach in the year 2021, Lordship.
No, but are they not similarly situated?
Lordship,
They are not similarly situated.
maybe otherwise issues.
My lord, the last order was of 25th of
All right,
January.
we'll give you time till next Wednesday. Fixed item.
Right.
Mr. Srinivasan, learned counsel for the petitioner, also heard Mr. B. Chakravarti, learned CGC, who seeks time till next Wednesday to obtain instruction on the prayer made in his petition. Full stop. In view of the above, registered to list this case again on 22nd of March 2023 as a fixed item.
Obliged.
Yes. So rest of the matter will take up. Yes, Mr. Chaudhary, what is your case?
Items 34 and 35.
Will-
For order. My lord, in item 34 and 35 are in item 34, my lord, 1 week time was granted and your lordship granted 10 days time for filing of the affidavit. In item 35, the order has been passed at the time of motion. That what will be the result of the item 34, that is 5623 of 2021. It will be there in item number 35, this is 2022 case. So the department is filing the affidavit in item 35 as filed, but department has not filed in the item 34.
So anything to be done, we'll take it up at
Today.
2. I'm rising now. There is some meeting. Second up.
Copy to. My lord,
Second up. Will the CGC appearing here?
He had, SK Mehdi was, he had informed that some matter was fixed at another court. Yes, passed up.
Then we'll take it up some other day.
Obliged.
Mr. M. J. Kadil, counsel for the petitioners present, none has appeared for the respondents. Stroke Union of India. Full stop. Since the Lanet CGC is not present, let this matter be posted again after 2 weeks.
Yes, madam, may I pay for a fixed date?
Sorry, you are appearing?
Yes, ma'am.
We have just posted it after 2 weeks.
Last opinion, my lord, court allowed him some time, my lord. Then, my lord, in the last occasion, my lord, your lord have observed that this is second round of litigation, my lord. In the first round of litigation, there is an order, my lord. After discussing all aspects of the matter, my lord, this honorable court in paragraph 8, my lord,
The termination was not set aside, my lord. Termination of the.
my lord, may I submit, my lord? This honorable court had, my lord, page number 82, my lord, disposed of the matter, my lord, after discussing all aspects of matter, and held that, my lord, the petitioner is entitled for, my lord, appointment in any other post, my lord, after examination of his physical and mental condition, my lord, as per standing order of the department, my lord. And there is a specific direction for, my lord, a recommendation of his case for appointment, my lord. And, my lord, in the last part, my lord, there is a observation that it is made clear that the termination order which is under challenge will not stand as a bar in considering the case of the petitioner for rehabilitation.
So
Yes.
considering afresh, that will be for fresh appointment.
As per standing order, there is provision for rehabilitation.
Mr. Kadir, you are not understanding one thing. You are asking for a fresh appointment
No,
or
my lord, no,
that cannot be done unless the termination order is set aside.
my lord. Then, my
That
lord,
is an error. You have to get it corrected.
I may be allowed to, my lord, amend my this prayer of this petition, my lord. I will include this prayer for termination, for setting aside the.
That I don't know, but even that will be wrong.
Yes,
You have to get a review of the earlier
yes,
order.
my lord. Lord, if I may be allowed.
All right, you do it again, the court will decline relief to you. You have to get a review of the earlier order and say that the
Yes.
termination order is accordingly set aside.
Yes.
So that was not done. See, that is the problem. When you get hurried orders, this is what it lends you into.
Yeah.
Nothing can be done by this court.
Earlier order will pass after 5 years.
Nothing can be done. You should have pointed it out to the learned judge. Termination order is still holding the field. How can he be taken back in service?
I think one of the observation made by the.
All right, I can adjourn it. Otherwise, another court without me. I'm not getting into this kind of arguments. His service is terminated. You are not getting his termination set aside. You want him to be considered for another post. How is it permissible under the law? These orders are never going to be implemented. I'm not passing these orders.
May I amend
This court will pass orders which the court is satisfied is in accordance with law. I'm sorry.
After 2 weeks, this may come.
That is on the prayer of Mr. M. Kadir Council, I want to continue. Made with the consent of Mr. S. K. CBC appearing for the respondents. This matter is directed to be posted again after 2 weeks, so as to enable them to obtain updated instruction. You have to do what is correct. If you don't know, you ask someone who knows. Seek help. Why are you unnecessarily pushing things in the court?
I will do.
If his termination order is not set aside, he cannot get appointment or adjustment in another post. It is as simple as that. The audit will hold objection. The CAG will not allow it. Nothing will work. You just want an order to give it to your client. That's all. That is your purpose. But our purpose is to administer justice. And if you don't understand after being pointed out, what can be done?
I will file my.
All right, next matter.
All
Please.
right.
No, why? Is it the last matter? No, this is. Which one? Yes.
The government sir was supposed to bring instructions for you regarding pending DP.
Yes, pending.
Departmental.
DP. Who is appearing, Mr. Chutia?
But I am looking for number 5, madam. What I feel.
Response number 5 is
Directed, madam.
Well, today we have filed an additional affidavit, my lord. What happened during the last day, my lord? Witnesses never appeared, my lord.
what is the stage of the DP?
On last occasion, my lord, on 22nd of February, my lord, they were called for to record their evidence, the witnesses, my lord, but they did not turn up. my lord. And this is the order passed by the state inquiry officer. My lord, may have a look, my lord. We have filed today only, my lord. It's not in records. Last page, my lord, Annex B.
So what happened on February 23?
Nothing
22?
happened, my lord. They did not turn up. Even date is not fixed, my lord.
All right, you take down, heard Mr. R. Chakraborty, learned counsel appearing for the writ petitioner. This petition is directed against the departmental proceeding initiated against the petitioner. First up, Mr. Chakraborty prays for quashing of the departmental proceeding on the ground of inordinate delay. First up, he submits that on. What is the date of the affidavit?
Well, today's date.
He submits that today, that is
Yes.
13/3/2023, an additional affidavit has been filed by the petitioner, bringing on record documents to show that no progress is being made in the DP, but due to pendency of the proceeding, the petitioner's promotions have been held up. First up, Mr. T.C. Chutia, learned additional senior government advocate Assam, appearing for respond numbers 1 to 4, and Mr. Das, SP Das, learned counsel for respond number 5, does not have specific instruction as to the stage of the departmental proceeding.
I have got my instruction, my lord, that we do not have any comment because the DP has been conducted by the government.
Actually, Mr.
We are
Chutia
directed
says that, he does not have specific instruction as to the stage of the departmental proceeding. Mr. SP Das, learned counsel for the respond number 5, submits that since the inquiry proceeding has been initiated by the government, his client does not have any stand in the matter. First up, since the complaint in the writ petition is on account of delay in conclusion of the DP, thereby causing prejudice to the interest of the petitioner, this matter is directed to be posted again on 21st of March 2023 as a fixed item by tagging the affidavit dated 13/3/2023 with the record of this case. On the next date fixed, Mr. Chutia to obtain written instruction and appraise this court as to within how many days the departmental proceeding will be concluded. First up, depending on the instruction obtained by Mr. Chutia, an attempt will be made to dispose of the writ petition on the next date fixed.
All right.
May I please allow it? My
Yes.
lord, this is the contempt case, my lord. The most of the contemnants have retired most probably, my lord, and the petitioner also, I do not have the contact numbers, my lord. So matter may be adjourned for 3-4 weeks, my lord. By this time, I'll write a letter to implicate new
So
persons.
2015 contempt case, what will survive in this?
My lord, that's what, my lord, I need some time, my lord, to take
What is
this.
the order?
Order was there, my lord, operative part was there, my lord, to treat the petitioner as a reserve force in malaria department, my lord. Operative part, lordship.
Malaria is gone from the state. What will the petitioner do now?
Lordship.
Hmm?
Still, my lord, it is there, my lord, operative part, lordship will see page 58, para 7, my lord.
Mr. Jay Borguel and counsel for the petitioner submit that the respondents in this case have already retired from service and he is not in contact with his clients since many years. Therefore, Mr. Jay Borguya prays for and is granted 8 weeks time to obtain updated instruction from the petitioners and appraise this court as to whether any live issue still survives in this proceeding.
Lord.
This case accordingly.
Obliged.
Item 32.
None appears to the petitioner on call. This matter stands adjourned for 4 weeks. Yes.
Item 33 to 35. Item 33. Item 33.
None appears for the parties when the matter is called up. In view of their work, this IS stands adjourned for 6 weeks.
Item 34 and 35.
34 and 35, I say 1 week time for filers of rejoinder affidavit. Today I have received the affidavit of this state.
34 and 35. We'll give you 2 weeks, 1 week, not possible. Mr. S. Nath, Nanak Counsel for the writ petitioners prays for and is granted 2 weeks time to file rejoinder affidavit. Mr. D. Gogoi, Lanet Standing Counsel, PH Department, Assam, and Mr. S. Vishwakumar, Lanet Counsel for the respondent number 6 are present and do not have any objection if the prayer is allowed. In view of the above, registry to release this case accordingly.
All right, all right.
Item 36.
Please, my lord. In this matter, I would like to pray for withdrawal of this matter to with the liberty to file afresh, since we have not been able to communicate with our client, my lord.
That is not a ground of withdrawal with liberty.
My lord,
You want a appointment of arbitrator.
my lord,
Then why you want to withdraw?
my lord, talks of negotiation were going.
Then you take time. You take time. You can't withdraw and file again because your client is not traceable. That's not a ground. Your name, please?
A. Borua, my lord.
Mr. A. Borua, Learned Counsel for the petitioner submits that some updated instructions are required from the petitioner since talks of negotiated settlement was going on between both parties, and therefore this matter be adjourned for 6 weeks. Prayer allowed, this is the case accordingly.
I'm obliged.
Item 47.
May I please, Lord?
Yes.
Lordship, matter was decided in tune of Devdutt's case, my lord, and thereafter it was reviewed. And on the last occasion, my learned friend has already submitted the communication, the order, which wherein it was decided that the adverse remark, it was kept unsensed. So, and the same communication was communicated to me through WhatsApp by the learned counsel. And though it was not informed to the petitioner, my lord may close the sometime or I've gone through it.
Challenge the order, this new order.
I've gone through it. It seems that board has reviewed the matter.
What is the date of the order?
29/11/22, my lord.
29/11/2022.
My lord, my lord, it may be kept on the record, man.
Heard Mr. B.M. Dekal and counsel for the petitioner, also heard Mr. R. Dhar Learned Counsel appearing for the respondent numbers 1 and 4 who submits that in terms of the order of this court, the reviewing authority has reviewed the order and passed.
My lord, it is 15/11/22. 15/11.
Passed. Order dated 15/11/2022, rejecting the plea of the petitioner.
Yes.
Therefore, nothing survives in this contempt case. First up, I have perused the order dated 15/11/2022 and find that the same gives rise to a new cause of action for the petitioner. In view of the above, this contempt case stands closed by retaining.
My lord, a liberty may be given to challenge this.
Yes, yes. We are retaining the copy of the order dated 15/11/2022 with the record of this case. The petitioner will be at liberty to challenge the said order by filing appropriate petition. Contempt case stands closed.
Much obliged, my lord.
Item 38.
You may kindly pass over the matter for the time being.
My lord, here we have filed a affidavit.
What is the order about?
It relates to release of his salary.
Which is the page number of the order?
It's page 27 of the contempt petition.
Page 27.
My lord, page 27, para 12.
So what has happened? What is there in your affidavit?
We have released, my lord.
You have released.
We have released, my lord. Now, my lord, in this contempt petition, what they're trying to do is, my lord, they're trying to bring in a separate writ petition, my lord. If they are not satisfied with the thing, my lord, that we have released, they have to come, my lord, in a fresh writ petition.
1 minute. In your affidavit, where have you stated?
My lord, page number 53, running page, my lord.
Hmm.
Not 53, my lord, 51. It will start from 51, my lord.
Where is the relevant?
We have quoted the para 12, my lord. Then this annexure A, B, my lord. These are the
How many petitioners are there?
three petitioners are there. 58, my lord. Page number, there is a.
So in paragraph 8 of your affidavit, you have mentioned about 2 of them. What about the third?
My lord, third. I'm coming, my lord. 1, 2, 3. We have mentioned, my lord.
So 4,80,000 each for Dr. Rajesh Sharma and Dr. Nani Gopal Goswami.
My lord. Total 13 lakh, my lord.
Yes, so what survives? If you are aggrieved by it, file a fresh petition.
The whole amount has not been received.
All right,
Lordship.
then you file a fresh petition. Heard Mr. MP Sharma.
With regard to the third petitioner, Lordship, she is the widow of the late member, Lordship, and with regard to that, Lordship, she did not receive, a negligible amount has been received by her, Lordship. So. that has-
No, this para 8, this is not correct. Are you saying para 8 of the affidavit? That information is not correct.
No, Lordship.
Huh?
This calculation, Lordship, although that was sanctioned, Lordship, but then.
No,
they did not
calculation,
receive-
we are not concerned. They are showing, see the documents. They are showing that
although that-
3,06,000 has been paid after deduction of tax.
Lordship, although that amount was sanctioned, Lordship, they did not receive the whole amount, Lordship.
Have you filed affidavit?
So the exact amount, Lordship, that could not be ascertained, Lordship. That was clear.
On the prayer of your Mr.
I'm MP Sharma.
MP Sharma, this matter stands exempt for 6 weeks. You are neither responding to their affidavit nor accepting it, going on playing the same song again and again. They said they have paid this 3,40,000 to your client and
I shall
4,80,000.
file it, Lordship.
Then you file it. Let's see. Next matter.
My lord, my name will be shown in the cause list, my lord. It's
Let
not-
this matter be listed again by showing the name of Mr. Arthur Learned Counsel appearing to the respondents in the call list.
Right, Lordship.
May it please the lordship. Lordship, as per the office note, respondent number 2 has appeared, but respondent number 1, neither AD card nor any unserved notice has been received.
Who is the respondent number 1?
Vikram Kohli.
You are for respondent number? Why have you not complied with the court order? File our affidavit. This is a contempt case. We'll call that person as for personal appearance. Respondent number 2 is serving as what?
Respondent number 2 is Kalpana Sutar. She was the wife of the late Chandrachakti Sutar, first wife. And Vikram Kohli is the commissioner.
So you have to take fresh steps then. All right. Heard Ms. A. Bora Learned Counsel for the petitioner. Also heard Ms.
M. Bora.
M. Bora Learned Counsel who has entered appearance on behalf of respondent number 2. Full stop. Office note dated. Office note indicates that service is yet to be completed on respondent number 1. As such, petitioner prays for and is granted leave to take fresh steps for service of notice upon the respondent number 1 by registered post of AD. Steps within 3 days from today.
Item 40.
Like,
My lord, in this case, we have taken steps, but as per office note, my lord, this contemner rejected the refuse, my lord, the notice. In the, my lord, the office note it is stated due to change of subject, my lord.
Refuse for changing subject means?
But as per our instruction, my lord, the name of the office is my lord, name, and it is named as, my lord, Commissioner and Secretary, Medical, Education and Research and P&D Department. But same person is holding the post, my lord. Can he refuse, my lord?
Yes, what are you watching? Movie? Good movie. Share with us also. Yes. Why is your officer refusing court notice in these grounds? Siddharth Nath Singh, IAS.
Item number 40.
Yes.
I am
You are
not-
watching movie. He is refusing court notice.
No, Lordship, I am not watching movie,
Acha, you are
Lordship.
not watching movie.
Yes.
All right, but tell
Last
us
one.
what to do with him. You go through the record and tell us whether we should direct his
This
personal
is
appearance. Just have a look.
14.
Have a look at the
Contempt,
record.
contempt case, Lordship, I am
Yeah.
not.
Maybe, but you find out. Ask whoever is there.
Yes, Lordship.
It seems he has refused to accept the court notice. Maybe Ms. Bhattacharya can help you. They are refusing court notice in contempt matters. What is the way forward? Yes. What is the next matter? We'll call up the next matter.
Item 41. Yes, Lordship.
Lordship, in this matter, I am appearing for both the contender and Lordship. All the court order has been fully complied, Lordship.
My lord,
And-
senior counsel will be appearing, you can hire is in, let's in another court, Lordship. Can it be possible?
Court order has been complied with. What has senior counsel got to do with it?
Lordship, they have filed an affidavit, Lordship. Otherwise, we may grant it some time to file a reply in the affidavit, my lord.
No. What is the order? What is the direction?
Lordship, affidavit.
The court's order, your lordship will find at page 12, my lord.
See, Mr. Your name, please.
Karim, my lord.
These are cases, you can't keep these matters pending and again listing. They filed affidavit, you should be ready to tell us whether the order has been complied or not. I'm closing this matter now.
My lord,
You have 5 minutes to ask your client if you want.
my
This
lord,
this business must stop now.
my lord, order is not complied with, my lord. My lord, there was a direction of this honorable.
Let us see what is the direction. Where is the direction? Which
The
page?
relevant portion, your lordship will find at page 25, my lord.
Page 25.
Page 25.
Yes.
There are 22, my lord.
This fresh show cause notice and all this has been issued, Lordship. The inquiry has been completed and the further action has already been taken. And regarding Lordship, the period of 6 months, Lordship, we already paid and they have admitted in this petition, Lordship, that we have prayed for granting another 6 months time, Lordship. As because till April 2022, there was no municipal board functioning in the state of Assam, Lordship. So as soon as the new board took over Lordship, they already taken decision and they started acting on this. And the time was too short. That's why Lordship, the present contender, they approached before this honorable court for granting further 6 months time, Lordship. So further 6 months time was within, it was granted less 4 days time, Lordship. But we completed on the next day. It was up to 16. On 17, we complied on, that means the inquiry report was submitted, Lordship. And regarding subsistence allowance also, Lordship, because that time the petitioner was dismissed. And because by virtue of the order of this honorable court, he has been reinstated, but because of the inquiry proceedings, Lordship, he was kept under suspension. So we paid the entire till February, Lordship, all the subsistence allowance has been paid.
My lord, I have an instruction
1
that-
minute, where have you stated it? Your
Lordship,
affidavit?
I went through the file, Lordship. The affidavit is not there, but I can share my affidavit, Lordship.
No, affidavit is not there.
Yes, Lordship, I have
But
checked
then
the
we'll
file.
have it with along with the affidavit. Heard Mr. So-and-so, Mr. Karim, Lanet counsel for the petitioner. Also heard Ms. M. Bhattacharya, Lanet counsel appearing for the respondent. who submits that the order of this court has already been complied with, whereafter an affidavit has been filed on
We filed on tenth lordship,
from
10-3. Yes, lordship.
2023. However, I find that the affidavit is not on record. In view of the above, register to tag the affidavit filed by the respondents with the record of this case and list the matter again in the next week. In the
Yes.
meantime, parties, petitioners counsel to obtain instruction.
Oblige, your lordship.
Deeply obliged, your lordship.
Item 43.
May I please, as your lordship? My lord, the matter was notice was issued by this honorable court, my lord, and there is an interim direction, my lord, to fix my pay as per the revision of pay rules also. But till date, no any affidavit, my lord, no action has been taken by the state, my lord, in view of the order passed by this honorable court, my lord. My lord, admittedly, there is a departmental proceeding is pending, my lord, against the petitioner. That has also not yet been, my lord, culminated with any logical conclusion, my lord. Lord, may I pray, my lord, that my lord may dispose of the petition, my lord, by directing the respondents to conclude the departmental proceeding, my lord, within a fixed time.
What is
limit.
the stage of the departmental proceeding?
Let's say we have received the instruction, so kindly 10 days time may be granted for filing the affidavit.
Departmental proceeding was initiated when?
My lord, the so-called notice was issued on, my lord, 5/12/2014 at page 82, my lord.
So what is the present stage?
Lord, they are repeatedly issuing me, Lord, letters addressed to me, asking me to bring their witnesses along with me, my Lord. How I can bring their witnesses, my Lord?
What is your answer?
That's it. File our affidavit within 10 days.
No, you give me the answer first. What affidavit? Why are you asking him to bring your witnesses? Is it permissible under the law? Who is asking it? Who is
My
asking?
Lord, kindly peruse page 123, my Lord. This is the page 123, my Lord. This is a letter from Joint Secretary to along with me, my Lord.
So this is a notice issued to the witnesses.
My Lord, witnesses and my Lord, secondly. Oh, my Lord, after this, my Lord, 22, now they have issued notices, which is after the petition was filed, my Lord. Those notices have been issued to me, asking me, Lord, to bring the witnesses. My Lord. Those is not part of the record yet. I can bring those on record also. My Lord, they can file their affidavit also.
Mr. A.R. Learned Counsel for the petitioner is present. Ms. N. Bora, Learned Standing Counsel, PNAD Assam submits that she has received instructions and therefore granted 3 weeks to time to file affidavit. Prayer allowed. Let this matter be listed again after 4 weeks. In the meantime, the respondents to file their affidavit. The petitioner would be at liberty to file rejoinder affidavit thereafter.
The interim order which they have passed in the very motion stage, my Lord. That has not been complied with, my Lord.
File content.
Obliged.
Item 44.
May it please his lordship. Service is completed in respect of respond number 7, 8, and 9 on the last occasion.
And who is appearing for 1 to 6?
I am for 1 to 6, my Lord.
Then let it come up for admission. Your name, please.
Bidas.
Ms. B. Das, Learned Counsel has appeared for the petitioner. Mr. T. C. Chutia, Learned Additional Senior Government Advocate Assam, is present on behalf of respondent numbers 1 to 6. Office note dated 2023 indicates that service of notice is complete on respondent numbers 7, 8, and 9. In view of the above, office to verify as to whether any counsel has appeared for the respondent numbers 7, 8, and 9, and thereafter list this matter for admission by reflecting the name of all the counsel for the parties in this case.
Bless.
Item 45.
May I plead the lordship, as per Laojima Code order dated 28/2/2023, service is complete. Lordship, matter may be listed for hearing.
I go to Lojima court order, no? Mentioned to this, I go to Lojima court order. Who is appearing for 1 to 5?
I mean, otherwise, this is less than 3 years service matter, the covered case.
We will dispose it of.
Lordship.
Your name, please.
MSU Hazarika. MSU Hazarika.
MSU Hazarika, learned counsel for the petitioner, Mr. J.K. Parajati, learned counsel appearing for respondent numbers 1 to 5. Huh? Then 1, 3, and 5, and Ms. N. Bora, learned standing counsel, PNRD department for 2, 3,
2, 4, and 6.
2, 4, and 6. None is 2, 4, and 6. The rest of it is covered. There is already an order. Judgment dated 31/2023.
1646.
Who has rejected SLC?
SLC.
Yes. So get that. Give me the number. Disposed of.
Obliged.
Item 46.
Please, Your Lordship. Actually, kindly peruse the last order dated 10/2/2023 passed in IA 313.
Yes, what is the instruction? What is your prayer in the IA?
Lordship, prayer is that the judicial department, the relief which we are seeking regarding fixation of our pay in terms of the ROP rules 2017, that has been granted by the judicial department with the concurrence of the finance PRU department with some error. The application of PSP in the calculation of the pay has been wrongly shown. So the High Court, by subsequent letter dated 23rd of December 2023, had written to the judicial department pointing out that this is how the pay has to be fixed in case of High Court employees. So if the clarification as sought for by the High Court is approved by them, that is the end of the matter. That is why the instructions were sought for by them.
Yes, who was the instruction?
Government advocate was supposed to
We
judicial
have filed
department
affidavit.
already.
No, but
these-
there is an order of
Yes,
10th of
sir.
February.
Yes,
Okay, so what is the instruction?
In this regard, I have not received any instruction.
Why there is a court order? Why you have not received instruction? The court order has to be complied with, is it not?
We have filed our affidavit on January, let's say.
No, the order is
Yes.
of 10th of February.
10th of February.
So if you continue to say this, then we'll have to direct your officers to come. What is your
1 week
personal
time
appearance?
required. No, lordship, I will take instruction within 1 week. Let's say.
Yes, because they have been waiting since the year 2017, these petitioners, they are employees.
Right,
of
had
this-
Ms. D. Borgohain, learned counsel for the petitioners, Ms. H. Borua, learned government advocate Assam, Mr.
I'm appearing for Mr. H.K. Dasmiller, respondent number 3 and 4.
Ms. H. Borua,
For
government,
1.
correspondent number 1. Mr. Your name, please?
You Pathak Lordship for.
Pathak for
H.K.
3 and
Das.
4. And Mr. H. Halia,
Respondent number.
respondent number 2 serially available are present. However, despite the order dated 10/2/2023, the learned departmental council have failed to obtain instruction. Full stop. Ordinarily, when the department fails to issue instruction despite a specific order of the court, the only recourse left open for the court is to direct personal appearance of the concerned officials. However, in view of the request made by learned counsel for the respondents seeking time till 27th of March 2023 as last chance to seek instruction as called for by the court. These matters are directed to be listed again on 27/3/2023 as fixed item. It is made clear that if no written instruction is made available to the departmental council on the next date fixed, this court will consider directing personal appearance of the concerned official.
This can be taken up for final disposal also based.
Supplementary list for orders item 49.
Next legal also. As per also large amount order at the 10/3/2023 also. The studies is complete.
Then let it be listed for admission.
Lordship.
Mr. J. Kalital and counsel is present on the petitioner, Mr.
SM Hassan, Lordship.
SM Hassan and counsel has appeared for respond numbers.
Lordship 2, 3, and 4, Lordship.
2, 3, and 4.
Lordship 1, 2, 3, 4, Lordship.
1, 2, 3, 4. Office note and Lojima court order dated 10/3/2023 indicates that service of notice is complete on the remaining respondents. However, none has appeared for them. Be that as it may, the registry to list this matter for admission again after 2 weeks, after verifying whether any counsel has entered appearance for respond numbers 5 to 8.
Obliged.
Item 50.
May it please your lordship, by office order dated 10/3/2022, my lord, the service upon respondent number 7 has been completed.
Heard Mr. S. P. Sharma, Learned Counsel to the petitioner. Perused office note dated 10/3/2023 will goes to show that service of notice upon respond number 7.
Delivery note, my lord, is a delivery consignment, item delivered.
Is complete in this case. Who's appearing for 1 to 6? Since the respond numbers 1 to 6 are represented by the learned standing counsel PWD, Assam, hence registered to this case for admission hearing in the appropriate column.
My lord, may I just place one thing, my lord? Last occasion, my lord had fixed it for consideration of interim order, but because it was placed for orders, so I could not press for the same. So my lord, a short date may be fixed, my lord, for that.
What interim order you are seeking?
My lord actually had my lord's order in my lord's order on 2/2/2023, my lord. Instruction was sought for, my lord. With this regard, whether the judgment has been judgment and order of this high court has been complied or not. One to one of 2019, my lord. Page 61. Page 61? Page 61. Above.
So what interim order you want?
My lord, if the instruction is there on their behalf that they have complied with it, that ends with disposal of this writ petition itself, because then because this in the order that I have been affected with is not the last part, is that till the substitute is posted in due course and until further orders, if they interfere with the gradation list with the judgment of this honorable court, my lord, then automatically, as because the seniority come merit as per the order, so I would.
No, there is an order of the court directing them to review the gradation list.
Yes.
Was any time frame given?
No, my lord, there was no time frame given. My lord,
Then that is another matter.
that is another matter.
You are saying the junior has been made in charge.
Yes, my lord. Despite of this order being communicated to the department.
So today, what is the order you want?
my lord, as per the last order, my lord had asked for an instructions.
I'm not
Yes.
asking what
My
is the
lord,
order.
my lord, that no, that the temporary charge already been taken over and is, so till the status quo.
Mr. Sharma, last day also I remember you were totally hazy. Today you are even more hazy. When you are in the High Court and arguing matter before a single judge, at least, you should be clear on what you want. Otherwise, how do you get an order? You want an order, but you can't, three
No,
questions asked, thrice I have asked what is the order you want. You are unable to say.
No,
Next matter, please. So I was willing to pass the interim order today itself, if you could, but you could not even tell the judge what is the order you want. You are referring this, you are referring
No, I
that.
was just ready. I apologize.
Item 25.
Who is appearing?
My lord.
Yes, what is this matter?
The matter regarding my lord.
My lord, there was a status quo order. So I think lordship is fixing the matter on some other date.
Yes, but he wants continuation of the order which has already been vacated. Not vacated, not extended.
And expressly not extended or by?
No, it was not extended. So I asked him, what is the status quo here? He says he has been appointed.
Yes.
So he
So
wants.
by virtue of the status quo order, though my appointment was set aside by the authority, I continued with that. Till next that lordship may maintain that.
No, but in between, what has happened?
No, my lord, lordship, no, there are orders of the Honorable Supreme Court also, until and unless that order is not expressly extended by the court. Sometimes it may so happen matter is not listed. Say, supposing the order is till the returnable date. So in such situation, my lord, lordship has been considerate. Lordship will fix the matter sometimes in the next week. Or after this function of the High Court.
You will also be busy.
Yeah,
Mr.
yes.
Actually, on the last day, prayer was made before the honorable court to extend the.
So what will happen if the order is not extended? You will become the Gaubura.
No, he will not be.
Actually,
There is no order in his favor.
That's one.
but in review order is in favor, in my favor.
That's correct. So now if the order is not extended, you are opposing the extension. What will happen? You become the Gaubura.
No, no.
Then why are you jumping around?
I have informed them.
You have informed. All right, I heard Mr. K. Chaudhary, Senior Counsel, Mr. Daswans, appearing for the writ petitioner also heard Mr. S. Duttal, Standing Counsel, PNRD Assam, PNRD, Revenue Department Assam, appearing for the respond number 3, Ms. S. Burua, Government Advocate, Assam.
1, 2, 4, 5, 6, and 7.
1, 2, 4, 5, 6, and 7, and Mr. S. Salam, Counsel for respond number.
8 version.
On the request of learned counsel for both the sides, let this matter be listed again for admission hearing in the 3rd week of April 2023.
We have to, I will have get instruction and file affidavit.
In the meantime, respondents.
Have it decided in more than 1 month.
Right.
Lordship, dates may be fixed, Lordship.
Okay.
Choose a date.
Well, like, could it be on my lord 26th or 27th is a Thursday?
This is the case again on 27th.
April, my lord.
April 2023. Interim order passed earlier to continue.
Deep level.
For hearing, I can 47.
All matters over. Okay.
May please, your lordship.
Yes.
Well, the question here is, my lord, that at the fag end of my career, my date of birth was rectified by the senior audit officer without following the rules, my lord, as provided under the SR 8, my lord. So, my lord, on that basis, I approached this court, and the court, by its order, dated, my lord, page 3740, my lord, directed to produce my certificate and everything before the authority. I have produced that, and that was not considered. And my lord, what happened here, my date of birth was shown as 1954, some overwriting was there. When the audit department came there, my lord, they had put it to 52. And I was being given the retirement, my lord. So, my lord, that's only the question now before your lordship, whether they can change the date of my birth without giving an opportunity within the 3 years of retirement. And in the affidavit, they have admitted that the senior audit officer has said that I have given the administrative decision, but who has changed it, I don't know. Anyway, my lord, but this is clearly covered by the one Supreme Court decision in 2022. On that ground, my lord, it can be disposed of, my lord.
But is he still in service?
No, he's retired, my lord. In 14th, he's retired prematurely.
So if your prayer is allowed, then what will happen?
I'll get the retrospective effect of my service. Yeah, my lord. But what if it cannot be changed, my lord? 54, he cannot change from 54 to 52. It will be 54. That is the date of birth. The lordship will go para 16, 18, 20, 21, and 22, and 23. The recently one, my lord.
Para
16 year lordship. I made it clear that it is not a case where the workman is seeking to change his date of birth. It is here also, my lord. I am not seeking to change, but to his benefit at the end of his career. There is a case where the employer is altering the record. Here is the case, my lord, where they have done it. Because there was some.
the employer has changed the record.
Yes, my lord. I have not changed it, my lord, because my date of birth, there was some overwriting. I am a 4th grade employee, my lord. I am not assessed to this, my service report, my lord. Because at the time of my entry, I have produced my school certificate, that is 56, my lord. But somebody has, just before my retirement, they have changed it to 54. I am a grade 4 employee, Chokidar, my lord. So the employer has done this, my lord. They cannot, my lord. That is what the Supreme Court says, my lord. Record end of the career, the workman for his determined to taking the unilateral decision. They have taken the unilateral decision, my lord, that the date of birth specified in the applicant's service book was erroneous, relying on the date disclosed in the statutory form. Standing the clause 5, the standing order, we have already expressed our view on the evidentiary value of the entire form D with as regard to the date of birth of the workman. In the committee report, the DP and so, my lord, that is not essential, my lord. Last week, your lordship will come to page 18, my lord. 18. The employer has taken stand that due to the date of birth recorded in the applicant in the service was not an act by mistake. This is a weak explanation in our opinion. Several subsequent steps were taken by the employer in relation to the applicant's employer on the basis of the entry in his service book. The employer are the custodians of this record. They acted along with the basis of the service entry till the appellant took the VRS. It has been pleaded by the applicant that at the time of his appointment, the office of the respondent company entered all the records of his date of birth as 21st September 1949. In the light of these facts, we are not inclined to accept the version of the employer that the service book record was a mistake, and the employer, a public sector unit in this case, was expected to act with the certain element of responsibility in maintaining the service record of their workmen and ensure that there is a uniformity in the particular concerned individual employees. There's no explanation as how this mistake occurred and how the payslip exam content to be issued carrying the mistake date of birth for such a long time. The High Court is our view ought not to have accepted the mistake as a cause for the different entries in the different documents. Then, my lord, para 20, my lord, the said document came to the existence after the applicant was released from the service on the 3rd October 2002. No documents of earlier origin in this record has been brought to our notice in the courts of hearing of this appeal. The applicant complained against such a decision on this. The process of fixing the applicant's date of birth has continued beyond the date which he was released from his service. We don't think that applicant's complainant over the dispute was belated as to the non-suit him as is on this account alone. VRS benefit is entitled. They assume the character of the property the employer is conveying once the application of VRS is accepted if the right of the person under 300 Article A of the Constitution of India, the VRS benefit be given to the accurate assessment thereof, the employer being the public sector unit, if the time of the quantifying of the VRS after the employee accepting the application voluntary retirement, the employer take the step that would reduce such benefit in the monetary terms, such steps has to be taken under the authority of law. We find that the action of the employer like lacking in authority of law in this case of 2 counts. First, it fails for not or adhering to the principle of material justice. The decision not follow the service book record was taken without giving opportunity of hearing to the appellant. The opportunity of hearing to appellant also incurred because the employer themselves has proceeded on the basis of the later date, that is 31st September 49, was the birth date of the applicant, and this was a long established position. Moreover, since it is the own record of the employer's 2 dates were shown, under the normal circumstances, it would have been incumbent on their part to undertake the exercise on the applicant's mind, determining which 2 dates, which 2 record the mistaken has slipped in. The process would have been to involve the participation of the applicant, which has been compatible with the principle of natural justice. Now, there are the several authorities in which the court has deprecated the participation on the part of the employees on the fag end of their career to dispute the record pertaining to the entry of the date of birth that would have been effective of extension of the length of their service. We are not interfering with those authorities in the judgment. The ratio laid down in that on that account by this court is not relevant for adjudication of this appeal. The very reasoning for which the employer is not permitted to raise the age correction at the fag end of the life, fag end of his case service is extended to his tenure would also apply to the employer as well. It is the employer here who has proceeded to the basis of the age of the applicant reflected in the service during the later service. The principle of the estoppel cannot be invoked in the case against the appellant to debar him from claiming the benefit properly computed as per his age reflected in the official document. Occasion did not arise for the applicant to avert it to the age correcting process so far as the entry in the form be concerned, and then the employer themselves has treated this date of birth as 21st September 1949 and the service book. In these circumstances, we are of the opinion that the division bench of the single judge and the High Court that appreciate the materials available in the proper perspective. We don't think the view that taken by the division bench was a possible view. Certainly, sustaining such view would result in depriving of the appellant of his legitimate benefit under the applicable voluntary retirement scheme. The material relied upon by the applicant were ignored altogether. Here also, my lord, I have submitted in pursuance to High Court's order, I have submitted my date of birth and everything before the authority for correction because there was an overwriting. That was not considered, my lord. We thus set aside.
Mr. Bhattacharya,
Yes,
the other part, there is no difficulty in appreciating.
Yes, ma'am.
You need not labor on that.
No.
We don't have any doubt that unilaterally the employer cannot alter the date of birth recorded in the service book to the detriment of the employee. What I am asking is,
Yes.
We accept your plea.
Yes.
What is the relief that can be given to the petitioner at this stage?
I am not asking again, since with this decision, I cannot also within the 3 years of my last leg of the career, I cannot go for correction of the age also. But in pursuance to the High Court's order, my lord, I have placed my documents before the authority.
You are not.
No, I'm coming to that, my lord.
We are granting your prayers. They are illegally.
I'm not for the service. That pensionary benefit will be given to me from my date of retirement, that is 54. If I take it on the record 54, I get the 2 years benefit, my lord.
So you want only that your pension.
Yes, my pensionary benefit is to be on the salary for 2 years, which is due to be in the service, has to be made to me. That is my
So
prayer.
you will be treated to be notionally in service.
Yes.
Till your actual date of retirement.
Yes,
And your pension to be calculated.
I'll calculate
accordingly.
on the basis of.
All right, what is wrong in this? We'll allow this?
My lord, actually, respondent number, my lord, I am as a formal party. Respondent number 2 and 3 is the main party insurance, my lord. Yes, sir. Nobody is appearing, my lord, on behalf of the respondent number 2 and 3. He is appearing for AG. He AG.
So
that-
has notice been served?
Yes, my lord. It's the
And if
nothing
they
but-
don't appear, they don't
But
appear.
they said that they have nothing to do because it is the insurance respondent number 3, my lord, is the party main. He is the employee under the insurance medical officer, employee state insurance.
Yes.
Yes.
Yes,
And the two, my lord.
Yes, sir, my lord. That's why I'm saying, my lord. So one thing is, Lordship can note of page 42, his certificate was in Nepal. And that was translated by a notary in Nepal in 2011. And he says, as per date of birth, according to his notary, date of birth is 29 April 2058. He is saying, apart from that, no document he submitted before the authority. That is the, my lord.
All right, what is his actual date of retirement?
My actual date of retirement would be, my lord. If it takes 56, my lord, it will be around.
No, not 56.
If it is from the original 54, my lord, as it is there, then it is 2014.
What is the date?
Date, my. I'm just going.
31/12/2014.
31/12/2014.
And when did he retire?
He retired on, my lord, on 11, my lord. I'm just giving the date. He came to.
30th April 2012. Yet in the
Yes.
age of 60. 30th April 2012, he
34, 2012. 2 years they have superseded.
So his date of birth was recorded in the service book as 1/1/1954.
Actually, it would be, there was.
No, forget
Yes,
56.
they, according to them, it is 52. But they have.
54.
What was recorded in his
Yeah,
service
54,
book?
mine.
Then why are you going to 56? 56, you forget it.
Over 54, mine.
It was unilaterally changed as 1/5/52.
2.
And then he was retired from service on
Service,
34.
yes.
So your case is that they could not have unilaterally altered
The
your
54.
without giving you an
Giving
opportunity.
under section 60.
Correct. So if that is accepted,
That is accepted.
then your date of retirement would be 31/12/2014.
14. Yes.
Right.
Yes.
And so therefore the difference of this they should give you notional benefit
Benefit.
and calculate your pension accordingly.
Yes, ma'am.
2 years.
2 years.
Yes.
So
I had heard Mr. K. There's nothing much to argue here. What will you argue?
I have nothing to say because my lord, that's number 2 and 3 was to be.
No, but they have not appeared.
Not appeared. That was pass and order. Apparently.
Affidavit has been filed by respondent number 3.
Yes.
Yes, my lord, I don't know, my lord, who is appearing.
4 and 5 also filed. So what to do? What do you have to say?
There's nothing to say, but lordship, during the time of audit, lordship, we have found some discrepancy in the date of birth, lordship. That is our affidavit, lordship. That is our only lordship.
But that is not the point. Point is, if there is anything wrong in this date of birth recorded in the service book, it cannot be unilaterally altered.
Yes, Lord.
That's the law.
Yes, Lord.
Heard Mr. K. Bhattacharjee, learned counsel appearing for the petitioner. Also heard Mr. T.C. Chutia, learned additional senior government advocate Assam appearing for respondent number
1.
Respondent number 1 and Mr. R.K. Talukdar, learned counsel appearing for respondent number 4. None has appeared for respondent numbers 2 and 3, although they were duly served in this case. Full stop. The facts of this case lie in a narrow campus. The writ petitioner hearing was employed in a grade 4 post under the respondent number 3. On 1/01/04/1975.
Yes.
Full stop. He was serving under the respondent number 3 as a night chokidar. Full stop. As per the entry made in the service book of the petitioner, his date of birth was recorded as 1/1/1954. full stop. Since the date of retirement of employees serving under the respond number 3 was 60 years. Hence, according to his recorded date of birth, the petitioner would have retired from service on attaining the date of superannuation with effect from 31/12/2014. Full stop. However, just a few years prior to his retirement, his employer, that is the respond number 3, had unilaterally altered his date of birth recorded in the service book from 1/01/01/1954 to 01/05/1952 without serving any notice upon the petitioner or giving him an opportunity of showing cause. Full stop. Consequently, the petitioner was asked to go on retirement with effect from 30/04/2012. Full stop. The pension paid to the petitioner is also by taking account of his date of retirement from service as 30/04/2012. Full stop. Assailing the order of retirement of the petitioner, Mr. Bhattacharjee has argued that once an entry of the date of birth of the employee is recorded in the service book, the same cannot be altered by the employer unilaterally. That too, to the detriment of the employee, without giving him an opportunity of showing cause. In support of his above argument, Mr. Bhattacharjee has placed reliance upon a decision of the Supreme Court of India rendered in the case of Shankar Lal versus Hindustan Copper Limited, reported in 2022-0 Supreme SC 336. First step. Mr. Bhattacharjee has therefore prayed for an order interfering with the date of retirement of the petitioner and also to issue a writ of mandamus to give him notional benefit of service up to 3/1/12/2014 for the purpose of computation of his pension on account of the fact that the petitioner has retired from service way back in the year 2012. Full stop. Mr. T.C. Chutia, learned additional senior government advocate Assam, submits that there were certain discrepancies overwriting in the service book which had prompted the employer to take the aforesaid recourse. Full stop. However, according to Mr. Chutia, the respond number 3, which is the employer of the petitioner, not being present before this court, there was no scope for him to improve on the case of the respondents. Full stop. Similar is the stand of Mr. Talukdar, learned counsel appearing for the respond number 4. Full stop. As noted above, there is no dispute about the fact that the writ petitioner was serving under the respond number 3 in a grade 4 post, and he was asked to retire from service with effect from 30/4/2012 on purportedly on attaining the age of superannuation. Full stop. It also appears from the materials available on record that the age of the petitioner as recorded in the service book was 01/01/1954, but the same was altered subsequently by the employer and re-recorded as 01/05/1952. Full stop. There is no dispute in this case that the alteration of the age of the petitioner was done unilaterally and without giving any opportunity of being heard to him. First stop. Based on such altered age, that is reduced, altered age, the period of service of the petitioner got reduced and he was sent on retirement with effect from 30/4/2012. Full stop. In the case of Shankar Lal, bracket Supra, the Supreme Court has taken note of the decision of the employer to unilaterally alter the date of birth of the employee and held that such a recourse was impermissible in the eye of law. Firstly, on account of not adhering to the principles of natural justice. And secondly, that the principle that there can be no alteration in the date of birth of an employee at the fag end of his service would be equally applicable to the employer as well as the employee. Full stop. That's the issue. Full stop. After a careful analysis of the facts and circumstances of the case, I am of the view that the ratio laid down in the case of Shankar Lal bracket Supra will be squarely applicable to the facts of the present case as well. Full stop. The respondent number 3 had clearly committed an error in unilaterally altering the age of the petitioner recorded in the service book just on the eve of his retirement and compelled the petitioner to go on retirement on a date prior to what was acceptable to him. Full stop. Whether there was any justifiable ground for the authorities to do so or not cannot be an issue in this proceeding, since no opportunity was ever granted to the petitioner to show cause in the matter. Full stop. For the reasons stated herein above, this court is of the opinion that the writ petition succeeds and is hereby. This court is of the view that the writ petition succeeds and is hereby allowed. However, since the petitioner has already retired from service, the writ petition is disposed of by directing the respondents to fit the petitioner to be in service up to 31/12/2014 for the purpose of notional fixation of his pension, and thereafter give him the arrear dues, if any, payable, arrear pensionary dues, if any, payable as per the rules. Full stop. The aforesaid exercise will be carried out and completed within a period of 90 days from the date of receipt of a certified copy of these orders.
Item 13. Yes, my lord, this matter pertains to selection and appointment of constable in Central Armed Police Forces, lordship. And the advertisement was issued on 21/7/2018 and XR 1 page 17. Lordship, in that case, petitioner offered his candidature for the post of constables and he participated in the recruitment proceedings. In the recruitment proceedings, lordship, there are the 4 stages. First one is computer-based examination, second is physical efficiency test, third is physical standards test, and fourth one is medical examinations. And petitioner qualified all the examination except the medical examination, lordship. And
Who's you are appearing?
lordship, in that case,
Just a minute, just a minute.
lordship.
So what is the relief you are seeking?
Lordship, may I please just give him a direction to constitute a special medical board with an doctor in the specialist in the relevant field and to ascertain my fitness. If I am fit, upon it, Lordship, or if I am unfit, I have no claim, Lordship.
Lordship, you will look at the opinion of the private doctor, Lordship.
No, you forget the private doctor. It's a question of a review medical board.
Lordship. Otherwise, Lordship, the ground is ground for rejection as per the medical guideline. This is the followed. This has been reflected in the advertisement itself. That
This was,
2015
the process is for which year?
2018 advertisement, Lordship. Much water has flowed down, Lordship. It is too late now, Lordship.
2018, but Lordship.
And all vacancies have been filled up. Is there any interim order?
Lordship, there is no interim order, but Lordship, that still today, Lordship, that series matters, staff selection commissions. That matter has still come, Lordship, even on today itself, is taking the ground that fence sitters. Still today, some matters has been come before this court.
This recruitment process.
Is this recruitment proceedings? Because some reservation policy has not been
On
followed.
those cases, Lordship, there's petitioners were superseded by down below, Lordship. That is the ground there. But here his rejection was on medical.
And Lordship, if post is vacant, they may appoint it, Lordship. If not vacant, Lordship.
Can't be done.
Lordship,
Can't
but
be done like this.
my prayer is only to ascertain my the physical fitness.
But
Lordship.
what to do? You have not got an interim order from the court. Today, if you succeed also,
Lordship.
then whose post will be given to you?
Lordship, exactly.
Lordship, then if some post is vacant, Lordship, they may.
If it is not vacant, then you don't have a case.
No, Lordship, yes.
Append that instruction.
Yes, Lordship.
If you put up something to say that there is no post vacant, as per that advertisement, we'll close this matter.
Lordship.
All right. How much time you want?
1 week time, Lordship.
All right. Mr. H. Bezbura, learned counsel for the petitioner. Also heard Mr. B. Chakravarti, learned CGC, appearing for the respondents who seeks time till 21st of March 2022 to obtain written instruction indicating as to whether any post under the aforesaid under the connected selection process is still lying vacant as on date. The instructions be obtained in writing so as to enable this court to pass further orders. If all posts are filled up, then you agree nothing can be done here. Where will the post come from? Otherwise, we'll consider. Otherwise, we'll see if something can be done. That's all. Any other matter? Yes. Item 40, contempt case.
Yes, Lordship, here I've gone through the file, Lordship. Siddharth Singh is not the Commissioner and Secretary in the Health and Family Welfare Department, Lordship. So Lordship may grant the petitioner some time. In the meantime, I'll let them know who the actual contemners will be, my lords.
Oh, you are impleading the wrong person.
Yes,
then.
Lordship. He is not the Commissioner and Secretary, my lords. Health and
My
Family.
lord, earlier, as per our instruction, earlier he was the commissioner.
No, Lordship. Health and Family Welfare Department don't have a Commissioner and Secretary at the moment, Lordship. So I'll have to see the content, my lords, and I'll help them or I'll give them the appropriate authorities.
Mr. Jiuddin, counsel is present on the petitioner. Mr. H. Cholia, learned standing counsel, Health Department, Assam, is present and submits that the respondent is not the Commissioner and Secretary of the Health Department, and therefore he has been wrongly imputed in this case. Mr. Cholia, however, prays for a week's time to seek further instructions and appraise this court as to the maintainability of this contempt case. They are allowed, lest this matter be listed again on 21st February.